have informed the respondent.
First of all, 512.
22, 23 to 37, 38 to 50, 51 to 60, 61 to 74.
62 Millard, item number 62 Millard, posted Millard on the request of the insurance company, referred to the Millard. 62. In this Millard,
64 to look at not settled.
only one request Millard. In this Millard, I have also informed other side. I have filed IA number 1 of 23 Millard because R1 husband in Millard died and wife is there. Son has died in the accident. Only these are two legal representatives. And I filed a petition Millard to substitute as LRs to the R1. The name of the R2 may be substituted. Only that could be ordered because in the local health again the same.
There are no other legal here.
There are no other legals. The wife itself filed.
Suppose if there are other legal here, they may raise it.
Death certificate is also filed, pending appeal.
We had counsel for the petition. Petition is ordered. I invoke the representation of the council that there are no other legal representatives against except the proposed LR.
63 Millard. And this is the report.
Already referred this.
63 Millard. There is a cross objection is there, that is not referred. I filed a cross objection in
The letter addressed to the registered Millard have made a specific mention.
Counsel representing the respondent informed the court that the cross objection filed by the
number 37 2021.
is not referred along with this appeal. The land counsel representing the insurance company informed the court.
CMA up to 2015 and up to this was withdrawn up to 5 years. And it taken up tomorrow.
The second notice has been posted for dismissal yesterday. So far is not listed.
Friday and Friday.
What submission Millard? CR number 2457 was the reserve for orders in April 12 of next year.
They will be disposed during this month. Don't worry. 24?
50 of 2020.
2450 of 2000?
Daily list for dismissal item what Srinivas Rao Utla and Ajay Kumar Madishetty.
That's matter Millard. Connected matters, Millard. Third of last week, third Millard. There are 12 matters listed.
Batch loan.
Batch one. Okay, a batch for
మీరు చంద్రయ్య ఉన్నారు అదేనా?
Madishetty Ajay Kumar. Matters are రేపు 10th ఉన్నాయి సార్.
కౌన్సిల్ రిప్రజెంటింగ్
batch Millard.
చూద్దాం.
Another, there are 4 matters Millard.
ఆ రోజు ఇచ్చారు కదా లిస్ట్ ఇచ్చినట్టున్నారు కదా.
ఇంకొక 4 ఉన్నాయి సార్. This 4 also may be carried.
Item 2. M.N. Ravikant Acharya.
And there is no representation. No agreement. And there is a representation. Nala Japan. None appeared for the appellant, though this You have already argued.
Yes.
Arguments of the other side.
Yes, my lords, I am ready.
Yes, sir.
My lord, the suit was filed against the appellant, who is the defendant, my lord, for an amount of 10,55,147, along with interest calculated at the rate of 24% up to the date of filing of the suit, which comes to 2,54,000. Altogether, it is 13,09,888.
Yes.
My lord, the suit was decreed on 16/4/2019 for half of the amount, which is about 5,85,013 rupees.
Yes.
My lord, the plaintiff could not file the appeal for the remaining balance because of his financial reasons. My lords, now the process of the supply made by the plaintiff to the defendant is like this. Plaintiff supplies ITC products, cigarettes, to the defendants. They take delivery. They pass a delivery note, which they call goods received note. And the plaintiff raises the invoices. They will have to process. This is all everything. Well, the court below found that though there are no delivery notes, there were receipts in the invoices itself by the defendant with their stamp. The contention of the defendant is that all these are forged and that such an amount is not due, number one. Number two, the supplies were not denied. However, there should have been a reconciliation of the accounts. On these two grounds only, defendant fought the case. Now, my lords, I would take your lordships to the defendant's evidence and the reasoning given by the learned court in arriving at the conclusion that the plaintiff is entitled to rupees 5,85,013. I would only restrict to that because since my learned friend has already read all the evidences, these two things would clinch the issue in respect of the decree, with which the appeal filed by the appellant should be dismissed. May I request your lordships to see in the judgment, internal page 8 of the judgment, para 16, 1-6.
Yes.
This is the portion of the written arguments filed by the defendant. Para 16, my lords, has it?
Yes.
It is stated that PW1 in his cross-examination admitted that he did not file any delivery channels and that the defendant might have rejected his claim on the ground that the bills were not accompanied by goods receipt notes. This is, they call GRN. This your lordships gets it time and again. Therefore, I am not trying to make it specific. Goods receipt notes. And that the defendant never admitted that any amount is due from its side. That PW1 admitted that he has not filed the entire correspondence and replies received from the defendant to his mail, and no interest was agreed to be paid on the amount due. Now, this is important. That as per the email, which is serial number 4 under exhibit A6, was sent by PW1 on 12/1/2011, the outstanding balance is shown as 5,85,013 rupees 50 paise, and the same is admitted by PW1, and it shows that the suit amount is not due to the plaintiff. Therefore, in the cross-examination of DW1, your lordships would be seeing this amount they are agreeing. Even this amount of 585 in the words of the defendant DW1 says he did not verify about the reconciliation, etc., which I would read. Therefore, the court has limited the decree only to this extent. This is a part of the written arguments. Millets, I think my photo is not coming, Millets. That I may be excused.
It's okay, no problem. You are audible, sir.
Yes, yes, sir. But therefore, my lords may kindly see how the learned judge has ordered the suit. Kindly go to page 10, para 19. Internal page I'm referring to. Para 19 of the judgment. From para 19, I would read the total.
Yes.
The specific defense of the defendant is that the defendant would pay the amount only against the purchase orders under invoice, which is accompanied with goods receipts notes issued by the manager, distribution center of the defendant company, or the stores manager of the defendant company, with whom the stocks are unloaded, and the said procedure is well known to the plaintiff, and that the bills raised by the plaintiff are not supported by any GRN from the concerned stores manager's signature, and therefore the said documents are created for the purpose of the suit, and the plaintiff has to prove the supply of material under relevant GRN by taking into the account the purchase returns. I would pause here and submit, except accountant in the defendant company, none of these goods manager, distribution center, etc., stores manager were examined by him to say that the GRN were not obtained. Only DW1 was examined, as who is the accountant, which is admitted. Now, para 20. Plaintiff filed 22 bills under Exhibit A1 in support of the suit claim. All the 22 bills under Exhibit A1 are containing the rubber stamp and signature of defendant, and as elicited from the cross-examination of PW2, there are some strike-offs in the bill invoice number so-and-so, dated so-and-so, and the same are not deducted by the plaintiff. This is the one thing which was found by the court against me, that in respect of invoice number 21, dated 21/2/2008, which was not deducted. Thus, the claim of the defendant that the plaintiff has not reconciled the account and not considered the purchase return seems to be true. Para 21. Cross-examination of PW1 dated 13/10/2017 shows that defendant issued goods return notes on sometimes and not issued such GRN goods on sometimes, and the defendant gave acknowledgement on the invoice itself for the supply of goods and denied the suggestion that the bills under Exhibit A1 does not contain the acknowledgement of the receipt of goods by the defendant. Therefore, I would just pass. Therefore, the defendant is trying to say whatever the acknowledgement given on the invoice with the rubber stamp is not equivalent to goods receipt notes. Therefore, they say you have not supplied anything to us to the extent of your claim. Therefore, you are not entitled. That seems to be the contention. Well, I can understand this if they deny that rubber stamp, and if somebody is examined to say that rubber stamp is created, and if the defendant has taken any steps to say that I have forged, managed, fabricated all these documents. They agree that all these documents have been received by them in the mail, and also they agree that I have given a notice stating all these things, that Exhibit A1 bills are pending from your side. They don't reply. In that view of the matter, the adverse inference should be drawn against them that they did not take any steps. Now I would continue. Though PW1 was suggested in his cross-examination that Exhibit A1 bills does not contain the acknowledgement of the receipt of the goods, the bills under Exhibit A1 clearly shows that, this is the observation of the court, shows that they contain the acknowledgement of the receipt of the goods by the defendant by putting the rubber stamp and signature of defendant stores. Therefore, the bills under Exhibit A1, even without the GRN goods receipt notes, can be considered as they contain the rubber stamp and signature of the defendant stores to show that those goods are received and acknowledged by the defendant. Am I audible, minutes?
Yes.
Yeah. Para 22. PW1 in his cross-examination dated 22/1/2018 categorically admitted that the statement enclosed to emails at serial number 4 of Exhibit A4 was sent by the plaintiff to the defendant on 12/1/2011, and it shows the outstanding balance as rupees 5,85,013.50 only. Since plaintiff claimed the outstanding balance as 5,85,013.50 on 12/1/2011, the plaintiff is not entitled to suit claim of rupees 10,55,147 basing on the bills under Exhibit A1 pertaining to the period 2007-2008. In my humble submission, though we have not filed appeal on this for his own financial reasons, but this observation is also not correct. But I may not have to make much submission on this because the learned judge has restricted my claim to 5,85,000 basing on my email, where under I said myself, the plaintiff said that the due is 5,85,000. PW1 also admitted that the said email dated 12/1/2011 is the last email. Therefore, the plaintiff cannot claim more than the admitted amount of 5,85,000. Defendant filed this statement of accounts marked as Exhibit B2 to B5 and filed purchase returns memo dated 30/4/2008 for an amount of rupees 12,560 only. Evidence of DW1 is not sufficient to disprove the claim of the plaintiff, as the cross-examination of DW1 shows that he is dealing with the accounts department and not concerned with the purchases. Defendant failed to examine any person from the purchase department to disprove the purchase bills, invoices claimed by the plaintiff. From the suggestion given to PW1 and the contents of serial number 4 of the emails under Exhibit A6, this court is of the considered opinion that the plaintiff is entitled for the amount of 5,85,013 only, as claimed in the email dated 12/1/2011, serial number 4 in Exhibit A6. Hence, this issue is answered. Therefore, the suit is decreed, my lords, you would see in issue number 2, 5,85,000 together with the interest at the rate of 12%, whereas I claim 24% from 12/1/2011 to till the date of decree, and thereafter 6%. Again, I claim 24%, only 6% is given. Well, now I would like to take your lordships to the admissions or what was referred to by the learned judge. At my learned friend has filed a book, paper book with examination and cross-examinations. My lords, I would invite your lordship's attention to page 23.
Yes, yes.
My lords, 23, my lords, unnumbered 1, 2, 3, second para, last 3 lines, my lords.
Yes.
Unless I verify from my lords, has it?
Yes.
Unless I verify from my email account, I cannot say if I have stated in my email dated 13/1/2011 that as per the statement attached to the mail, the account is due 5,85,000. Well, I would now take you to the defendant's cross-examination, which clinches the total issue. My lords would get it from page 39 minutes of the paper book.
Yes.
Last parameter, I am not aware whether
Yes.
the plaintiff is the sole authorized supplier of ITC products to Trinetra. Trinetra is the defendant. Witness adds, the concerned category person is only competent to answer the same. Well, I would pause here. I was trying to extract from the mouth of the defendant as to who are all the suppliers, whether there are any other suppliers or not, whether I am only the supplier, so that it will be easier. Now the witness says I am not competent, somebody else have to. That somebody else was never introduced into the court. The defendant company has not filed any document to show that other than the plaintiff supplied ITC cigarettes to Trinetra. So no document is also there. I know the contents of a written statement filed by defendant company in the above suit. Our contention, it has come out, sir. Our stand in WS of defendant company is that company made payments as per GRN, that is goods received note. GRN is a document which will be supplied to the supplier after receipt of goods. After issuance of GRN to the supplier, we don't keep any proof of GRN since it will be recorded in inventory register. It is true, in the email dated 12/1/2011, which was addressed to me, the Particulars of claim of plaintiff attached. I have gone through the contents. Witness acts. Subsequent to that, reconciled statement was sent to plaintiff. Witness again says, I do not remember whether such reconciled statement was sent to the plaintiff or not, but the same is mentioned in the written statement. I would pause here, my lords. My lords, now it appears there is a difficulty in reconciliation. I am claiming, for example, 10 rupees. They are saying you are entitled only for 2 rupees. Who will have to say? Well, they should say. Fine. If they don't send the reconciliation statement to you, to me in the email, they could have filed before this court. They did not do that. So how the court would know what is the amount due? Therefore, the court has relied on the email last sent by the plaintiff, whereunder the plaintiff claimed as outstanding amount of 5 lakhs, which was decreed. Well, and further reading. It is not true to suggest that the claim of the plaintiff is in respect of Exhibit A1 invoices. Witness adds he does not know whether claim of the plaintiff is for rupees 10 lakhs prior to sending ledger. It is not true that it is not that easier to verify the genuineness of the documents with the individual outlets. Witness adds that it is not necessary to verify with the outlets regarding genuineness because the only proof is GRN. I am not aware whether the company made any effort to find out the persons who endorsed invoices Exhibit A1. The defendant company has not given reply to Exhibit A3 notice caused by the plaintiff. I am grateful to this court. It is true there is reference in Exhibit A3 notice regarding Exhibit A1 invoices. It is true the defendant company has not taken in any of the emails that Exhibit A1 invoice are forged and fabricated. Witness adds, after receiving of legal notice Exhibit A3, only defendant company came to know about the invoices Exhibit A1. The defendant company has not verified the concerned record handbook of invoice of plaintiff to come to a conclusion that the signature and the seals on the invoices of Exhibit A1 are forged. Witness adds, I am not aware whether defendant company verified those records of Exhibit A1 invoice as stated above. Well, let's giving a pause here. Well, let's clearly defendant is accepting that they did not take any steps to verify my Exhibit A1 and the so-called fabricated, forged, created documents. They don't give police complaint also, which is coming later. Well, it's in that view of the matter, Exhibit A1 and the email have to be believed by the court. Well, I am continuing. It is true, in my chief examination of DW1 affidavit, I have mentioned in para 2, para 3 that the documents are created for the purpose of the case. It is true to say we have not filed any cases against the plaintiff with regard to the forging of the documents of our invoices. At this juncture, my lords can skip there. Then it is starting like this. Though I have not verified Exhibit A1 invoices with the outlets personally, I have stated in my chief examination that the stamps and the documents filed by the plaintiff are also different and they do not belong to the defendant company. Witness adds, I have verified with the inventory register and stated the same in chief affidavit. The emails dated 31/3/2009 under Exhibit A2, though addressed to defendant company, since I have not received any communication, I cannot say anything about the contents. I do not know whether the scanned copies of bills supplied under emails dated 16/12/2010 are disputed by the defendant company at any point of time. Therefore, who will have to say that this is disputed? Somebody else is there. Nobody is introduced. So I do not have any opportunity to bring out the real truth from the defendant's mouth. It is true. Yes, madam. Either in the written statement or in my examination affidavit, we have disputed the receipt of scanned bills under email dated 16/12/2010 covered under Exhibit A2. It is not true to suggest that the items shown under invoice dated 3/1/2008 to RSM Raju,
Amaraju, RS,
Ramaraju Nagar unit are different than that of the quantities and the description shown under email dated 31/12/2008 are one and the same. It is not true to suggest that though the same are one and the same, I am conveniently disputing the same to suit the defendant case. It is not true. It is not our case that throughout the proceedings, starting from filing of WS to giving evidence, all the invoices are forged and fabricated. Well, I would read this. It is not our case that throughout the proceedings starting from filing of WS to giving evidence, all the invoices are forged and fabricated. It is true in the defendant organization, there are different departments for sales, purchaser, marketing, etc. I deal with accounts only. I am not concerned with purchase like procurement of stock. It is not true to suggest I am not competent to depose in respect of purchases. I have verified the stock purchases ledger. I have not filed ledger. However, I have filed ledger extract. The ledger extract, page number 49 of list of documents filed by the defendant company was prepared manually and it does not contain the uh, nomenclature, signature, and the seal of the defendant company covered under exhibit B4. It is not true to suggest that the same is prepared for the purpose of this case without any basis. Therefore, this, my lords, I would submit. Therefore, this page number 49 cannot be believed if he is preparing with hand note without any signature, seal, etc. That is definitely prepared for the purpose of case to show that this amount is not due to them. The ledger extract that too. Next, Miller. It is not true to say that in all the communications and meetings with defendant company, through the plaintiff submitted relevant proof for his claim. The defendant was not inclined. This is not true, Miller. Though the plaintiff submitted relevant proof for his claim, the defendant was not inclined to pay the claim amount. It is not true to suggest only to see that the limitation for the suit claim lapses. The defendant company dragged on payment on some lame excuses. It is true. As per Exhibit B6 purchase return note, all the items shown relating to food items only. It is true. Cigarettes are fast moving items. The plaintiff supplies cigarette smellers. Witness again says, adds, I am not aware. It is not true to say that in none of the emails we informed the plaintiff that the plaintiff claim was settled. We have not filed such communication before the honorable court, but I have such proof. It is not true to suggest that the defendant company is not in habit of clearing the bills in time. I do not know who will communicate regarding stock of items or outlets, various outlets with the category persons of central warehouse. The concerned category persons from central warehouse will have the track of fast moving items. I know minimum base quantity and line fulfillment, but I do not know whether based on those two factors purchase orders will be placed. Likewise, I do not know whether purchase orders will be placed based on inventory register. Witness says the concerned person is competent to depose the same. It is not true to suggest that I have not replied even to the email addressed by plaintiff under Exhibit A2. Earlier, he said no reply was given. Now, suggestion is being denied. Witness says he replied and he has the proof for the same are not filed before the court. It is not true to suggest that the GRN is an internal document and I have not filed the same, which apprehension that the truth will come out. It is not true to suggest that the plaintiff supplied goods based on other mode of communication as was done in respect of Ramarajanagar outlet. The defendant company has not filed all purchase orders with respect to the transactions under the plaintiff. It is true. We have not filed the stock inventory register pertaining to ISB and other outlets covered under Exhibit A1 invoices. It is not true to say that I am deposing false. Well, it's my humble submission would be, having gone through the reasoning given by the lower court, and the evidence of defendants. My lord, the lower court has rightly decreed to the extent of the email outstanding which was admitted by the defendant and the plaintiff. My lord, there is no necessity of interference in this appeal matters. Therefore, appeal needs to be dismissed.
I think
We take your lordship for a short reply matter.
you are not disputing the evidence of DW1.
I'm not disputing the evidence of DW.
It is not your case that you have examined the other part.
The plaintiff proved his case beyond reasonable doubt. He cannot stand on the weakness of the defense.
In a money suit, when
Party
there is,
principle.
of course,
How far the plaintiff has proved his case, I'll take your lordship to the plaintiff's evidence. PW1 and 2. Only the relevant portions I read.
there is no dispute about the supply of goods by the plaintiff to the defendant.
But
And emails are admitted.
there goods. There were transactions. but
Email
goods are returned.
exhibit A1 is admitted by DW1.
No, he did not admit. At different points of time, the plaintiff started sending 5 lakhs, 6 lakhs, 7 lakhs, and 10 lakhs. It was confronted to him in the cross-examination. See, on so and so occasion, you have addressed only 5 lakhs. Even the other things were put to him. With regard to the reply notice, also he admitted. Now, I'll take your lordships to the cross-examination of PW1. He says, as if the defendant has to examine the concerned person. It's for the plaintiff to examine his own accountant, it is for him to prove his case. But, page 23, Miller.
Yes.
First parameter, line number 3 from the bottom. I have not filed any delivery challenge. But for making a supply method, is a company, a retail company, means a super retail company. It's a supermarket. I have to place purchase order with him. Only then he can supply under invoice to Sale of Goods Act or contract or anything. For that, first there should be a purchase order. He just can't say, I have supplied to your branch on oral request and I am entitled for payment. There should be goods receipt notes. For that is cross-examination. I have not filed any delivery challenge. Maybe the defendant has rejected my claim on the ground that the bills are not accompanied by goods receipt notes. It is true that the defendant never admitted the amount. So once the defendant did not admit the amount, it is for him to prove beyond reasonable doubt. They have mentioned the same in their reply notice. A young friend was arguing that no reply notice is given because that DW1 stated something. Here, plaintiff admits that it is stated in the reply notice also. Reply notice was in fact sent. It is not marked. They have stated the same in their reply notice as well as the written statement. It is true that my email is addressed as students. It is true that the staff of the defendant company asked me to provide bills in support of my claim. The said emails are marked as exhibit A2. One S. Raju requested me to provide the ledger copy for total bill from 2008 till February 2011. Here is the crux. Witness confronted with a bunch of emails sent from Isha Ventures. Isha Ventures is the plaintiff. I have pointed out to him that these are the emails sent by you. He says, unless I see the original my account, I cannot tell. So that is the evasive answer. He is confronted with the email sent by him. Witness is confronted with a bunch of emails sent from Isha Ventures. Witness says, unless he verifies from the mail ID, he will not be able to answer the same. But he is sitting in a cross-examination before the commissioner. A person cannot say, I have to go home and verify from my computer email ID. That is what he is saying.
Then how can he know whether they are really emails sent from his address or they were prepared by some other person?
If they are not
See,
sent
a
by-
bunch of
if he
documents.
is not sent, if he doesn't know, that is plaintiff fails to prove his case. Unless he verifies, he will not be able to answer them. I am not sure whether the defendant intimated through email dated so and so that there is no outstanding. Witness confronted with the mail. This is the defendant's mail saying that nothing is due. He says, unless he verifies, he cannot say. Unless I verify from my email account, I cannot say. If I have stated in email dated, this is 13 is stated, but it is 12. At times the amount is so and so. It is true that I have not mentioned in my chief affidavit or 65B certificate what kind of computer system the printouts are taken, or if it is taken from the same system. He should mention that it is from the system which is in regular usage. Each time he sends different mails with different amounts. That is the reason he is confronted. He says he is unable to say if it is from the same system from the beginning of the correspondence. Witness says that system is changed, hardware is different. So each time different system is changed, the ledger is different. Totally about 50-60 people are employed by me. Now my learned friend was pointing out that defendant examined DW1, he is from accounting section. He is not the proper person. They have not introduced a proper person for me to cross-examine and elicit from his mouth that this is it. So here is the case of the plaintiff. Totally about 50-60 people are employed by him in the section of food division. My learned friend was saying ITC supplies only tobacco products. ITC also deals with food products. ITC has got food also. It deals with basmati rice. ITC.
It is not your case that it is not the case of plaintiff that he supplied food to these
Yes.
different.
Now he supplied food also. Totally about 50-60 persons are employed by him. The total number of 50-60 persons. Next page, comprised of sales, accounts, delivery boys, loaders, drivers. It is true that accounts people maintain the ledger books in the computer systems. At page 24, approximately 2 or 3 systems will be there in the office. We use Wing software application to maintain. Accounts people will correspondence with the suppliers, including me. I also operate the system. So he's also not the right person. Like my learned friend was saying, DW1 is not the right person. He says there are 2 or 3 persons. Accounts people will correspond, and he also operates the system. I am not sure if all the staff correspond with the mails of Isha Ventures. I sometimes correspond through my personal email ID with the clients. It is true that I have not filed the entire correspondence. But at the plaintiff having latches like this, he has not filed the entire correspondence. 50-60 people maintain the accounts. The systems are different computer systems. 65B certificate does not mention that it is the regular computer which is in usage. It is true that I have not filed the entire correspondence and replies received by the defendant. It is incorrect to say that the amount claimed by me in the suit is different and not due to me. It is true that there is no interest agreed upon to be paid. I have not supplied the material and I am unable to produce the goods receipt notes and supply. I can produce the entire email correspondence with the defendant. It is not true to say that I am not producing the entire source. In order to avoid the correspondence, that no amount is due. Then he produced the other correspondence. Then he was cross-examined, which your lordship would find it page 25. The next page. It is true that all the bunches of emails under exhibit A6 are forwarded emails dated 5/12/2017. Well, that suit is of 2011. If suit is of 2011, these emails are of 2017. These are forwarded emails. So these are not the genuine ones maintained in the computer. 5/12/2017. The suit is of 2011. So he produces them just before his evidence. He forwards them from a different system, produces them. So that was put to him in the cross-examination. It is true that Vishnu is our person to whom the emails are forwarded from. So Vishnu was not examined here. Isha Ventures, I do not remember as to how many computer systems the emails are downloaded. Now he cannot even say from how many systems these emails are downloaded. Exhibit A6 contains correspondence between the plaintiff and the defendant. It is true that the suit is filed on 31/3/2011 and the correspondence which is forwarded, my lord, your lordship has seen 5/12/2017. It is true that under exhibit A6 we have mentioned the correspondence serial number 1 to 9. It is true that at serial number 4 of the correspondence, the email dated 12/1 addressed by me to the Ramakishore of the defendant company, stating that pursuant to the meeting in the office 7/1/2011, as per your request, we are enclosing the statement for your reference. It is true that the said email 2 months prior to the filing of the suit. I have enclosed the statement to the email at serial number 4 under exhibit A6. It is true that as per the statement, enclosed in the email of exhibit, which is sent by us on 12/1/2011. The outstanding balance is 5. So his entire case that he 13 lakhs is due to him, 10 lakhs plus 3 lakh interest falls flat with this admission. It's not true to say that in order to the emails, TSHC demanding payment along with the statement, it's also. It is not true to say that all the emails are created by our staff. Then, my lord, PW2 is the accountant. Our cross-examination is required. Just for me. Because he was saying my
Now
account.
you are giving replies, sir.
Pardon?
You have already argued all this. Now it is reply.
This is a reply, my lord.
Hmm.
Because he was trying to point out PW1's evidence is not sufficient. Now I am trying to show how the plaintiff has proved.
Hmm.
Page 30, my lord.
Yes.
She is the accountant. I have not found any document to show that I am working as an accountant. In order to prove his case, the plaintiff has examined himself as well as his accountant. Now the accountant says, I don't have any document to show that I am worked as an accountant in Isha Ventures from so and so. I will not be able to produce any documents such as salary certificate deducted to show that I was employed. I do not know if they made anything about the emails filed by the plaintiff. So she says she doesn't know anything about the emails. I followed. There is nothing to show that I followed up the dues of the defendant company. I cannot produce any email in my name to show that I dealt with the defendant's company. We are having about 50 people to maintain the accounts of different companies, which includes loading, unloading, drivers, supply. Along with me, there are 3 or 4 persons to look after the accounts in different companies. It's true that in Exhibit A6, there are variations. The last line, page 30. There are variations of amount shown as due. As per Exhibit A6, there are variations of the amount due. This was confronted to PW1. He says, unless I verify, I cannot say. But she admits, due to the defendant's company on different occasions. So he has been sending different bills on different occasions. So we could catch hold of one bill, which he admitted, saying that it is 5,85,000. And his court decrees that as if it is an admitted that 5,85,000. But the plaintiff has to prove that 5,85,000 is due also, he has not proved by filing. I cannot say anything about the email sent on 12. The ledger showing that the amount is due. I have not authored the statement of account. It is true that Exhibit A1 bills and invoices. This is important. There is nothing to show that they were prepared by me or I have read it. It is true that in Exhibit A1 bills, this is what my learned friend was relying. Exhibit A1 bills are read. There is no signature of any person who prepared the bill. Because these are all copies which are brought afterward by forwarding from different mails. That invoice should contain the person who prepared the bill. That is not there. It is true that in Exhibit A1 bills, there is no signature of any person to prepare tax invoices on behalf of each other. It is true that there is no stamp in place of column meant for signature of each other. What all is relying upon is my own stamps. Defendant has stamped the invoice. Merely by taking a stamp doesn't mean that he has delivered the goods. Anybody can give anything in the inverted security pillar stamp and give. That doesn't mean that is an acknowledgement. What I am trying to say here is there must be a purchase order. There is a distribution center where the goods have to be supplied. From there, they will be sent to the branch. Now, in the case of the plaintiff, that sometimes I used to supply on oral request to the branches and obtain their stamp from the invoices. Whether goods receipt notes was obtained from the concerned branches, that is not there. He has not filed delivery challenge. He examined himself and he says 3 or 4 computer systems it is downloaded. And your lordship has seen that the emails are forwarded on 5/12/2017. The bunch of emails. And the suit is filed in 2011. The accountant says she does not know anything about it. And he is trying to prove the case from DW1. The cardinal principle is the plaintiff has to stand on his own strength or it has to fall, not on the weakness of the defense. He has to prove that there were purchase orders and he supplied pursuant to the purchase orders and there are delivery challenges. The goods receipt notes have been acknowledged that these are the goods received by the defendant company. That should have been proved. Okay, simply because 5,85,000 is the last mail that is sent by him is admitted, the court has decreed that he should do that.
Right. Third counsel for the respondent.
Now admission item 4, while acknowledging and Bhajan Srinivas.
For the, I filed a LR petition and permission. What is the
Look at the petition. Yes, sir. Petition,
Don't have any objection. Counsel for the respondent reported no objection to will condone the delay to allow the LR application.
Item 5, Kushik Reddy KV and Khaja Mohyuddin.
None appeared for the appellant. Is missing.
Item 7, Anjali Agarwal.
History is direct to verify. Eleven. Rendu.
Item 8, adjourned. Item 9, Vikas Joshi and Gudi Madhusudan Reddy.
8 is not done.
8. He said he has already informed you.
Oh, I have to argue whether I am for the respondent, it is
Of course,
posted.
counsel representing the appellant wanted time because his senior was not is not available. And he said specifically that he has informed you.
He has not informed me, but it's okay.
When I asked him, he said that he has informed you also. Alright, it is your argument. It seems Tulsidas Gokul is not available. 5/12. He's had 3 weeks time.
It's inconvenient, but should I have next Tuesday?
It was not admitted. It is for admission, right?
Yes, madam.
Counsel representing that.
Next Tuesday.
14/11.
Item 10, Vikas Srinivas Reddy and brother Srinivas Murthy.
My lord, we filed for the amendment of the amendment petition for the ground B of substantial questions, my lord. The other side,
You are for respond. Have you received the copy of
for petitioner, my lord.
Have you
Substantial questions will be
Vikas Srinivas Reddy, have you furnished a copy of the petition to the other side?
furnished, my lord. They mentioned the no objection, my lord, for the, they have not filed the counter, my lord.
You have no objection. Then you have to argue on the additional grounds. Ready?
Okay, ready, my lord.
Yes. Go ahead.
Substantial questions that we had explained, my lord. Kindly see the.
Wait.
So senior counsel was supposed to be appearing in this matter, Your Lordship. We were told that this matter will be mentioned in the morning, Your Lordship. That is the reason senior could not represent. Lordship kindly return the matter.
First of all, argue on 1411.
Okay, my lord.
Item 11, Yamlingam.
Nagesh 33 కోర్టు పెట్టు నాగేష్ పెట్టు వస్తాను మన టైం ఉంటుంది.
Mute your Srinivas Reddy. It is not admitted. ఏమో చెప్తున్నారు మీరు?
Already sent notice to R1, but it was returned with the, it was left to the address.
No service. Right.
Who is R1 insurance company?
Whatever.
Had he contested the matter?
Settings.
What about the other respondent?
Students fresh person is order for
Proof of service filed. Shall I pass out? Professor Rappale, 1511.
Item 13, P. Vidyasagar Reddy and TSHC got on this Bhasha.
For the appellant in this matter, already copies are there. If they're not there in the section, I'm for it. Yes.
You're for the appellant.
I'm for the appellant in this matter. Wait.
Instead of verifying whether the copies are available or not, or
Because already it's not there in the section. Along with the
give him a copy.
Yes.
You're ready? You're for respondents.
Respondent 2 and 3.
Instead of R2, R3, wanted a copy of the petition. Allowed 1511.
Interim order.
Interim unte istan extend chestam. Next.
Item 14, MBBS Narasimhanidhi and J. Venkateshwar Reddy, G. Anand.
Pillar of appellant or respondent?
Respondent number 2 has
So you want to bring the LRs of R2. You filed wakalat for the proposed parties. Of course, you are for second respondent. Now you want to add some LRs. Have you filed wakalat for the proposed parties? As you file wakalat, you cannot counsel representing the second.
Krishna and D.R. Nachavaram.
May it please your lordship.
Yes, sir.
In fact, I'm extremely sorry to say this, your lordship, because this matter has been dismissed for default, and I filed a petition for restoration with a delay. And in fact, I filed my own affidavit, your lordship, for the delay.
Well, I'm allowing the application. Don't worry. 93 days delay. Have you served a copy of this petition to the other side?
In fact, the appeal, there are no merits in the appeal, Your Lordship. In fact, if Your Lordship for a moment sees,
Restoring and dismissing it.
yes, Your Lordship, because respondent's evidence nil, respondent document nil. And then there is nothing. He's a pastor, salary is proved, everything is proved. And in fact, there is no evidence on behalf of the insurance company, no oral or documentary evidence.
This week I'll restore the appeal and next week we'll see the appeal.
Yes, Your Lordship.
Counsel for the appellant. In 11.
Much obliged. I'm extremely sorry, Your Lordship.
It's okay, sir. No problem.
Item 16, R. Umendra Kumar, Damodar Mundra.
The respondents to 8, 9 and 10 years.
Request to extend the election, unable to contact parties. They reported last.
Request of appellant 2111.
Item 17, M. Krishna Reddy and Rajkumar Rudra.
Both responses. Or fresh notice to the
Issue fresh notice to R4. 1212.
What is refused now?
Notice. Refused, huh?
Yes.
R4 refused. R4 it seems notice was refused. If it is refused, there is no mess.
deemed service.
Sure.
Your Honor,
There is notice, the notice sent to the fourth respondent, returned with an endorsement that he refused to receive the notice.
deemed service. For the
1212. It is admitted, final hearing 1212. Get ready.
extent interim orders.
Interim order is there?
Yes, no, interim order.
What is the interim order in
Since
MSc?
beginning of interim orders are there.
What is that interim order?
Owner is now appeal filed by the owner, rear owner.
So you sought for stay of the execution.
Yes, no.
1212. Interim order unte extent. Yes.
Apply.
Item 18, N. Ashok Kumar.
Mention చేశారు కానీ since yesterday the matter was mentioned, then అది
Because admitted and stay of entry passing of the final thing was ordered. Have not drafted any date even I will
డేట్ ఇవ్వలేదండి ఎవరు లేలా డేట్ చెప్తుంటాను నేను అడ్మిట్ లిస్ట్ ఆన్ 7/11 డేట్ ఇచ్చాం కదా అంటే నెక్స్ట్ డేట్ ఇవ్వాలని final the final legal proceedings before the trial court are stayed except
any date your
proceedings are stayed.
date
List the appeal on 12/12 for final hearing. Till then stays there. 12/12.
Item 19, CI.
the copy may be
Right.
because it is not drafted.
Interim order కదా
Cell.
అప్లోడ్ చేయం కదా వాళ్ళు చూడమని ఒకసారి నాకు చెప్తారు అలాగే సార్
Item 19, CH Venukumar and KR Koteshwara Rao.
Your Honor, I'm counsel for representing Mr. Venukumar advocate, counsel for appellant. There was a delay for which the respondent said they will file counsel.
which was the respondent
Intermediate cantonment.
KR Koteshwara Rao.
there was a delay in filing appeal.
No. The same caption. Nobody represents the respondent. I'll condone the delay.
Item 20, J. Vijay Kumar Gaud and Ganga Prasad B.
The respondent. The delay to 162 days in this matter. File a counter in this. What is the appealing process? Three occasions.
Your appellant counsel, Ganga Prasad. Vijay Kumar Gaud. Screen మీద వచ్చిన కౌన్సిల్ ఎవరికి ఇది మ్యాటరా కౌన్సిల్ దేనిలో నాకేం కనబడలేదు. No representation for the petition. Counter లేదండి. And a counsel for appellant is also not there. Next.
Item 21 and 22, Jagapal Reddy Kasrete and A. Ramakrishna Reddy.
LR petition to bring the LRs of injured after filing the petition, after appeal he died. All his LRs are added. Where our layer? That's not counsel for the petition. Fifteen 11.
22 also.
Along with
Item 23, SR
Anna,
Association.
May
May it please your lordships.
just a minute, sir. Abu Balini and Indian Sandra Fusion left. Item number 80 low, written arguments as common. Mahbub Ali, Mahmoud Yar. Have you filed written arguments in item number 80? No, you said you are filing the written arguments, but it is not there in the record. Item 80. When it was, have you filed it before the registry? Epudu?
Written submissions.
అది ఎవరిది అప్పలెంట్
Ah.
ఆయన రెస్పాండెంట్ నేను చూసిన యూఎస్ఆర్ నెంబర్ చెప్పండి ఎప్పుడు వేశారు యూ సెడ్ యు ఆర్ ఫైలింగ్ ఆన్ 31st బట్ ఇట్ ఈస్ నాట్ దేర్ ఇన్ ది రికార్డ్ అమ్మంటిలో లేదా కౌన్సిల్ లేరా మన రికార్డ్ లో లేదు కదా ఆర్గ్యుమెంట్స్ లేదు కదా
లేదు లేదు.
సార్ వెరిఫై చేయండి రికార్డ్ లో లేదు అందుకే మిమ్మల్ని ముందు ఎస్ అది సార్ వెరిఫై చేయండి రిజిస్ట్రీలో వేసారా వేస్తే అది వచ్చిందా లేదా చూసి తెప్పించండి ఇలా ఇప్పుడు తీసుకోవద్దు ఎస్ ఇప్పుడు నెక్స్ట్ ఐటమ్ ఈలోగా ఎక్సర్సైజ్ కంప్లీట్ అవుతుంది
My lord,
ఎస్ సార్
may it please your lordships. My lord, in this matter, respondent number 2 died, my lord. We filed the LR petition to bring on records. First time it is appearing. Your lordship may kindly order notice, my lord.
R2
R2 died, my lord. To bring the LRs of R2 on record, we filed LR petition, my lord.
notice to the proposed respondents IA 1 of 23. Why only one application? What about set abatement delay? There is no delay.
There is no, we have filed in time, my lord, within 30 days.
Is to respond proposed respondents 1912.
My lord, may I request your lordship to kindly permit us to take out personal notice also, my lord?
Permitted, sir. Personal notice.
Item 24, R.A. Achyutanand and Syed Ilyas.
My lord, this review petition can be dismissed, my lord, because already your lordship has already dismissed the earlier petition, my lord. There are no merits in the present.
No, no.
For hearing item 25, Jyotishwar Gogineni. Penalty, giving the penalty involved. This is actually, in fact, what happened is, you know, at the time of admission, additional inting order has been passed. We have completed condition. So thereafter, you know, the penalty has been waived off. The pending due amount has become a regular zero. In fact, so far as my side is concerned, you know, the orders are necessary because it is a gap is setting the regard THMC. In fact,
The entire amount was waived or to the extent of 50%?
you know, in fact, that has become zero and some amount we have paid. 37 lakhs and now first 36 lakhs and now we have paid. And
So with that amount, remaining amount was waived.
yes, remaining amount has been waived off.
You cannot press the appeal.
Submit some material, my lord, before your lordships. We filed, my lord, an application before the DHMC.
Instead, you cannot press the appeal. There is no necessity.
No, in that even, my lord, tomorrow if again, my lord, the DHMC has raised any objection, my lord, that would be a.
What was the mode of waiver? Was there any order?
Get a NOC, my lord, from the this penalty is concerned. The NOC from the my lord of DHMC.
When
But those people, you know,
counsel representing the appellant was at the time of filing the appeal.
yes, at the admission. Milord, it's only in the tax receipts, the present tax receipts, they are.
So you have some proceeding.
They have to give us some proceedings, but people are not coming forward that, the TSHC authorities are not coming forward to give that such a letter.
Then what is the solution?
That notices have been served to the GHMC. Now I'll verify who is the standing council and I'll from them, so that they can get an instructions and.
Short time and records. 29/11.
Yes.
For final year in item 26, Ramakrishna K and P. Shavan Kumar Gaur.
I'm for the appellant. The originally two OS number 884 of the respondent number 1 before the second additional union. The suit was filed for injunction simplicity. The plaintiff claimed that he purchased the suit scheduled property under a registered sale deed exhibit A1 and his vendors purchased the said property under A2 and A3. But the original document under which the plaintiff claims title is exhibit A4 agreement of sale. Page 31, with your lordship, see. Exhibit A4 on behalf of the plaintiff is agreement of sale dated 16/7/1994, under which the predecessor of the plaintiff claims title over the property. That admittedly is alleged to be executed by the defendant himself, who is the appellant. My submission, Lord, is the plaintiff before the trial court claimed title over the property under an unregistered agreement of sale, based on which his vendors executed sale. Admittedly, the property belongs to the appellant. But the trial court initially dismissed the suit, holding that there is no cause of action. In the first appeal, Lord, it was reversed and the suit was consequently dismissed. Only on the ground of cause of action. The question of law, my lord, before your lordship, whether both the courts below were wrong in accepting the contention of the plaintiff when there was a serious dispute of titles raised by the defendant. That is the only question which deserves consideration at this stage in the investigation. The lordship kindly consider that admittedly the plaintiff before the trial court was claiming under an agreement of sale, which does not confer any title. And the defendant, that is the appellant here in the is the owner of the entire extent of land and measuring 6 acres 12 acres, in which plots were formed, and defendant, the appellant himself sold various plots to purchasers, and one of the plots out of the entire extent of 6 acres 12 acres is the suit scheduled property, which is plot number 32. The lordship may kindly see the judgment of the trial court and answering the issue number at issue number 1 at page 15 of the material papers and page 4 of the judgment. The preliminary burden of proof.
Yes.
The preliminary burden of proof is on the plaintiff to establish he is entitled for relief of perpetual injunction. The plaintiff got examined himself as PW1, filing examination in chief in the form of affidavit, repeating the contents of claim in a nutshell and marked exhibit A1 to A11, which are as follows. The lordship skips that sentence in the cross-examination.
Yes.
In the cross-examination, the PW1 stated that he do not know the total extent of survey number 14/1 to 14/4 of HIGHCOURT village, and he did not verify the revenue record before his purchase, and he do not know whether the total extent of the said land is 6 acres 12 guntals, and he do not know exactly where the suit property is located and in which survey number it is located. He further stated that suit plot number 32 and is vacant, and witness again added that it was vacant at the time of his purchase. And at this juncture, the learned counsel showed claim to the witness, and he admitted that it does not contain existence of structure. He denied the suggestion that he do not know the location of the plot since he is not in possession, and denied that his vendor has no title or possession over the suit property. He further stated that plot number 33 is seen under the signature of the This portion why I have read a lot is to show that the trial court has considered the claim of the appellant that the plaintiff has no title over the suit scheduled property, and necessary suggestions were given to the plaintiff to elicit from him that his title was not correct. That the appellant disputed the title of the plaintiff over the suit scheduled property. Next, if your lordship considers page 16 regarding exhibit A4. Fifth line. He further stated that he has not mentioned about exhibit A3, A4 and A6 and A7 in his claim, and denied that defendant number 1 never sold suit property to Krishna through exhibit A4, and denied that signature on exhibit A4 is forged and it is not belonging to the defendant number 1. He further stated that under exhibit A4 it is mentioned that sale consideration was already paid prior to execution of exhibit A4, and he did not file any receipt showing payment of sale consideration by K. Krishna to defendant number 1. He denied the suggestion that defendant number 1 did not receive sale consideration and did not give possession to K. Krishna. He further stated that he has seen the leaked document and exhibit A3 and A4 were handed over to him at the time of registration, and in the claim he did not mention that exhibit A3 and A4 are missing, and stated that he is ready to send the document under exhibit A4 and wakalat of defendant number 1 for comparison. He denied the suggestion that exhibit A4 was created on 16/4/2005 with antedate as 16/7/1994. He stated that exhibit A4 was impounded on the same day of application. So, and therefore, Your Honor, my lord, the appellant has been contending right from the trial court that the title claimed by the plaintiff under exhibit A4 was not correct. When there was a serious dispute raised by the defendant with regard to title in an injunction suit, my respectful submission was is not that the suit ought to have been dismissed on the ground that there are serious disputes with regard to title, and a suit for injunction simpliciter is not made. But the trial court only dismissed on the ground of cause of action. So it went into the favor of the appellate Milan, but the finding was only with regard to cause of action. At page 29.
Yes.
Page 29, the learned trial court held not that there is no cause of. The plaintiff failed to prove cause of. Therefore, it was held by the trial court that the plaintiff is not entitled to a decree, therefore the suit was dismissed. Now coming to the judgment of the first appellate court. Page 8, if your lordship can. The only point considered by the first appellate court is whether the appeal is maintainable or not. So far as the findings of the trial court regarding proof of possession of the appellant hearing or the suit plot is concerned, trial court rightly held that the contents of exhibit A1 and A1 to A3 and other supporting evidence, and also rightly held that the appellant plaintiff succeeded to prove his possession over the suit plot as on the date of filing of the suit. The primary ingredient to grant perpetual injunction in favor of a party is proof of possession over the suit plot as on the date of filing of the suit. In this case, trial court has rightly held that appellant plaintiff succeeded to prove his possession over the suit. So far as cause of action is concerned, in para 7 of the plaintiff, it is mentioned that the cause of action arose on 30/3/2006 as the defendant 2 at the instance of defendant number 1, along with some antisocial elements, forcibly tried to enter into the suit property and manhandled the worker. By filing written statement, respondent defendant denied the title and possession of the appellate plaintiff over the suit schedule plot. Denial of title and possession of appellant's hearing by defendant in this written statement itself is sufficient cause to institute the suit. One cannot expect the proof of cause of action in a suit. Cause of action shall be inferred on the conduct of opposite party. Therefore, contentions of the trial court that appellate plaintiff failed to prove cause of action to file suit is not substantial. Therefore, findings of the trial court in this regard shall be set aside. Now, my lord, both the courts below have failed to consider not that the plaintiff had no title over the property and the defense raised by the defendant, that is the appellate hearing lot, gives rise to a should have given rise to a finding that the suit for injunction simpliciter was not made. In support of my contention, I rely upon the judgment of the Honorable Supreme Court in AIR 2021 SC 429. Similar experiment, suit for permanent injunction maintenance. Suit for permanent injunction maintenance. Genuine dispute raised by defendant regarding title of plaintiff over suit property. Plaintiff's title over suit property is not free from cloud. Issue regarding title can be decided only after full-fledged trial on basis of evidence led by parties in support of rival claims. Suit simpliciter for permanent injunction filed by plaintiff without seeking declaration of right not made. Following this longer, my only contention will be the second appeal deserves to be allowed, and the suit of the plaintiff only for injunction simpliciter deserves to be dismissed.
Yes. Yes, your correspondence.
The second appeal itself is that no substantiation of power was involved. From your primary objection is that both the courts held basing on the evidence placed before them and basing on the witness examination of witnesses. Last week, kindly see the substantial question of law raised by the These all are pertaining to the
Of course, they are not, all are not considered. Only one substantial question is formulated by the court while admitting the appeal. It is whether the first applied court is justified in accepting the claim about the cause of action. Respondent plaintiff about his position on the suit scheduled property and alleged cause of action. That is the only question on which it is admitted. The finding of the trial court is with regard to the cause of action. Trial court found that there is no cause of action. However, while allowing the appeal, first applied court held that filing a written statement itself arouses the cause of action. How can we infer that cause of action? Filing of written statement will come to the picture only after the suit is filed. All right, what do you say? What about the position over the property?
Position is remains independent, constructed is deciding. The claim of the suit is just given in lecture because the position is not identifiable. The position is not vacant. Petitioner in the court procedure, he purchased and he obtained the permission from the complaint authority. He constructed the house.
Who?
He is residing in the same property.
Defendant. Who constructed the house?
The defendant. Plaintiff.
That is why I am repeatedly asking.
I'm sorry, plaintiff. I'm sorry. Plaintiff.
అందుకే మళ్ళీ అడిగినాను. Yes.
Therefore, this juncture
Both parties.
6-7 I write a memo. Substantial question of law with regard to the declaration of title is very.
That can be, if it is there, that can be formulated and while disposing the appeal also. All right, I'll have.
File the memo by serving.
28/11 for pronouncement of judgment. మనకి అది రికార్డులో పెట్టలేదు, నేను ఇవ్వలేదు. I'm giving a date, sir. However, written statement, written arguments that are not sent along with the bundle. And I don't know whether the counsel of the other side is received the copy. And వచ్చిన అప్పుడే పెడదామా డేట్, ఎలాగో నెక్స్ట్ వచ్చేసాం కూర్చుంటాడు. నెక్స్ట్ వీక్
Item 27, Chirapal Reddy custody and A. Ramakrishna Reddy.
In this case, you are asking documents have to come. Documents. Submitted by arguments so that it is both of us not with that.
కాదు, ఏదో పర్టికులర్ రికార్డు కోసం అడిగా. రికార్డు వచ్చినాయి.
After.
పాస్వర్డ్ నెక్స్ట్.
Item 28, Akadi Dayakar Reddy and V. Sameshwarao.
Yes, I'm sure I'll request for next week.
Request of respondent.
Item 29, V. Ramana and V. Murthy.
I will make it now.
Delay. Order అవ్వలేదు.
అదే నేను చెప్పలేదా లేకపోతే
చేయాలి అంటే ఫైనల్ ఇయర్ ఎందుకు వేసాను ఆర్డర్ అవ్వలేదు.
ఆర్డర్ రాసుకుంటారు. You are not ready.
I am for respondent, Your Lordship. I am appearing for a respondent.
Two weeks. 22/11. Counsel for the 2211.
Item 30 and 31. Yes.
Admission.
Item 30, 31. That's Ravan Kumar and K. Kumar.
And over the agents. What about the other side, sir? You're for claimant or you're for insurance company? Ready? You are ready? Commence your argument.
Yes, sir. Regarding the owner of the motorcycle. On the day of incident, he was going along his own negligence. Returned from the motorcycle, just a very repetition very relaxed. What do I have? Unfortunately, the judgment at page number 7. First of the judgment. Without making the claim is made under motorway act, the giant and several liability. He is the owner and he might claim against the insurance company. And this ground alone cannot claim under motorway act is not matter.
Petition was 163.
No, once even in 163A or 166 without making an insurance, the claim under motorway act is not matter. Because the liability under motorway act is only giant and several liability. Next one of that.
Petitioner himself is the owner of the vehicle.
Owner of the vehicle. He himself fell down the road and fight clear petitioner against the insurer. I'm laying the judgment from street road and coming to the judgment for because it's put in a number of cases. It was given the insurance company. Not been mounted with the liability when a claim is filed by the owner. This court regarding.
What was the finding about this particular issue by the court?
Without any discussion. Page number 13. Page number 13. The respondent, the insurance company equipped beyond the forest engine force on the date of action. Further, there is contention that as the petitioner is not third party and they are not liable to compensation with this petition not matter. Whereas RW admitted that an amount of rupees 50 is paid by the petitioner to respect the owner and it covers 1 lakh covered to the owner. Further, they also took condition that the petitioner was not holding driving license rather than that. To prove the same, they examined RW. On the other hand, the counsel for the petitioner condition that the respondent failed to prove that the petitioner was not holding driving license. On the date of the incident, part 2, RW admitted the rest of his driving license issued by the.
What about this particular portion of evidence of RW1 about the admission of?
The policy is in force, no doubt. Policy in force, but it does not cover the owner of the insurance. Earlier, this court will not in.
You see, in para number 10, the court observed that in view of evidence of RW1, that they have collected rupees 50 and it covers the risk of owner.
In case of that premium, collection of that premium not under personal accident liability, petitioner has to approach 4 months. The motorway act, motorway.
But you have not taken that plea before the tribunal.
We have taken, but it was not rejected by the court simply saying that already 50 is collected and cost was in force. They are liable. Not I am submitting on case of this court.
Insurance company and us. దానిలో అప్పాలంటే ఉదాహరణ చెప్తాను.
Directly based on paranormal 19. In Juma's case, the Indian bench of Honorable Supreme Court had an application to bring the that the liability of insurance company is to the extent of indemnification insured because the respondents are an injured person and third person are in respect of damaged property. The insured cannot be fostered with liability under the provisions of this act, provisions of the act, which we kindly observe this. Thus, if the insured cannot be fostered with liability under the provisions of the act, the question of insurer being liable to indemnify insured therefore does not arise. Owner of the vehicle, in Balra's case, another division bench of Honorable Supreme Court held that owner of a vehicle can only claim provided a personal accident insurance has been taken out. In that judgment, Honorable Supreme Court also referred to its earlier judgment in Oriental Insurance Company versus Sridhar 1998 DCJ 121, wherein it has been held that the liability of insurance company is only for the purpose of indemnifying insurance. Liability is incurred third person with respect to damage to the property. Thus, the insured, where the insured, that is, an owner of the vehicle has no liability to a third party, the insurance company has no liability also. From the above judgments, it is clear that the liability of insurance company is to the extent of indemnification of the insured against the third person are in respect of damage to the property, and insured cannot claim compensation against the own insurance company for his own negligence in the absence of any such coverage. In another case, not in Supreme Court judgment, where the Oriental Insurance Company versus the Dutch, this personal insurance claim collecting amount under personal liability was discussed. In this case, it has not been shown that the policy covered any risk of injury to the owner of the. They are unable to accept the condition that the premium of 4989 paid under the heading wound damage is for covering liability towards personal injury. Under the heading wound damage, the words premium on vehicle and non-arrestable assets. It is clear that the premium is towards damage to vehicle and did not for injury to the person which owner. An owner of vehicle can only claim provided personal accident insurance has been taken out. In this case, there is no such insurance. National Insurance Company was the national on the AR 7SC. 14 it has been held that where the claim against full damage claims it cannot be advocated in the insurance company by the insurance company, but it has to be decided another forum. That is forum created under the Consumer Protection Act 1985. Before the tribunal, there were essentially three parties, that is insurer, insured, and the claimant. But if there are no three parties, well, if the owner is not there as a respondent, the claim is not buttoned under motor regulation, but that was cleared with the judgment. That's not another one. This court not following the judgment law in English. Chenchu Lakshmi versus Hyundai Assurance Company Limited.
Citation this.
And in both para, liability of starts after some dot. Liability of the insurance company is to the extent of indemnification of the insured against the respondent or an injured person. Third person are in respect of damage to property. If the insured cannot be first with any liability. This one in the judgment, the Lakshmanan judgment was followed by this court, and appeal was allowed. The matter was appeal was allowed. This is the recent judgment not in 2018 judgment. National Insurance Company versus Sahashalata Bhumi. It's paragraph 7. Bottom from the bottom of paragraph 7. A claimant in our view cannot maintain a claim on the basis of his own fault or negligence and argue that even he himself may have caused the accident. On account of his own rash and negligence, we can nevertheless make the insurance company to pay for the same. Therefore, the respondent being the LS of sources could not have maintained the claim petition inspection once this is system motor vehicle. All the judgment will not have submitted clearly from that without making the insurer as a party, the motor claimant and motor vehicle act is not maintenance. Now, the petition ought to have approached the concerned forum or civil court not instead of filing this petition. Yes, I got to appeal and
Yes, fine.
the insurance company come back.
At number. Then R2 case.
సుబ్రహ్మణ్యం కూరేలా అండ్ కౌటూరు పవన్ కుమార్
ఇది ఏమైందంట 80లో అమ్మాయి.
ఫస్ట్ కోర్ట్ లో ఉన్నారంట వస్తారు.
Have you received copy of the written argument? When? Today or in the previous day? Is there anything to be added or shall we proceed with the 80లో ఏమంటారంటే even though they will have counsel for the respondent, the matter is taken up.
And for the applicant in this petition, my lord, CCC 242 of 2018, my lord, we need to submit the whole booklet. Please grant us 3 weeks of time, my lord. We'll be submitting the booklet for the respondents.
For respondents. Sir, when the matter was taken on 10/10, you made the same representation.
Yes, my lord. There was an unfortunate
lapsed
thing happened with our clerks, my lord. The booklet is with the clerk. So once you will get them, I'll submit to the respondent.
Same representation on the proceeding sheet. See, on 10/10.
That's very much true, my lord. That's very much true. Last chance may be given, my lord. I'll take. Much obliged.
Item 33, BL Prasunna and Kiran Reddy Mallarapu.
First of all, appellant's counsel 1611.
Item 34 and 35, Ajay Shravan Kumar and A. Viraswamy.
Viraswamy, representing. No representation for the appellant. 1611. Both matters on 1611.
Item 36, Ajay Kumar Manshetty and Ajay.
It is in the person. No representation of the appellant. 1711.
Item 37, account insurer and Durga.
Case of injury, she made a mistake that we take some time. Oh. We'll have it in the next week. Most of the appellant policy. 1511.
Item 38 and 39, K. Ajay Kumar, M. Ramakrishna, P. Mohan Prakash.
39. 37 is already adjourned, sir. 37 is not connected. 38 and 39. Connected with 39. 38 is not connected. Huh? Okay. Or our own individual issues?
One more connected case is the restriction. The same level of 2020 is connected to the 39. Item 39.
Level of 2020 is connected with item number 39. So 38 is a separate one. You are not there. It is brought to the notice. Oh, MACMA 1541 of 19. Which is tagged with this is nowhere connected. List is directed to list this head appeal separately. Durga, no?
Yes.
Already ready chamber. Ramakrishna garu leru kada. 38, no? So no representation. Item number 39. The court is informed. Messi method. 11.
Item 40, P. Vinod Kumar and Vladimir Khator, Muralidhar.
May I bring the lordships? Item party lordships.
Yes.
Lordships, I am representing for Vinod Kumar lordships.
Petition, there was no representation for it.
Yes.
The lordships, Vinod Kumar is no more lordships. 2 weeks to time may be granted, may not. Meanwhile, I will get the instruction from the client lordships.
The court is informed. No more. Vinod Kumar is.
Is no more lordships due to corona lordships.
Vinod Kumar, counsel.
Sorry.
2211.
Oblige your lordships.
Item 41, Srinivasa, Suresh Ram.
Because I am appearing for respondent defendants, my lord.
Sorry, for appellant.
It is a contractual dispute between the two companies.
This is an old appeals are get ready. I'm giving a date, but next time don't ask any adjournment, right? Request of appellant.
Very well.
Item 42, N. Vasudev Reddy and K. Pradeep Reddy.
And was there India? This is directed to Delhi. Ready, sir? The appeal was filed in 19, it was admitted in 20, now it is for final hearing. You got any another set of appeal grounds? మన దగ్గర ఉన్నాయా ఒక సెట్ కాపీ ఉందా? What are the documents you require? Petition and other claim petition and all other record is available with you. The only copy you require is the grounds of appeal. It is your headache. Obtain the record from the counterpart. 28/9/28/11.
Item 43, S. Surendra Reddy and V. Venkatram Reddy.
Appeal by the claimant. That was about more than 3 years ago. Why he is not interested to proceed with? అవసరం లేదా? Cost of appellant 28/11.
Item 44 and 45, Mr. Safiullah Beg and N. Vasudev Reddy.
May I please? The present appeal is filed by the claimant. Well, it is a case of injury, my lord. The appellant before your lordship sought a claim for 25 lakh rupees, my lord. 25 lakh rupees. The amount awarded was 5,03,000 rupees, my lord. But for the enhancement of the claim, the present appeal is filed. The petitioner before your lordship, the appellant is working as scavenger in GHMC.
Yes.
But all the heads, the trial court, considered all the heads except one with regard to the injury. Due to the accident, her leg was amputated. And only 90,000 rupees was assessed for the injury. But that is the only ground I am raising. In pain and suffering, 50,000 was granted, but 1 lakh ought to have been granted. Well, it is the claim. Lordship will see. Para 17.
So what is the evidence in support of the alleged amputation? Have you examined the medical officer?
Yes, my lord. The medical officer, your lordship may get para 17 of the judgment, my lord.
Yes, sir.
This court reappreciated the evidence of the medical officer who is examined as PW3, coupled with relevant documentary evidence, which are marked as Exhibit A3 and A5, clearly substantiate the version of the PW1 with regard to the injury sustained by her. Of course, learned counsel for the respondent tried to shatter evidence as he could not succeed. It is very much pertinent to note that the documentary evidence coupled with the evidence of PW3 medical officer, who is not at all interested witness, moreover, he is expert in the field, so his evidence has to be considered by the court as true and correct. But in the evidence of PW1, the medical officer who is examined as PW3 is taken into account in consonance with the relevant medical records of the petitioner. She is a retired employee from GHMC. She might have spent amount required in medical bills to retain her health condition. So the petitioner is entitled to the claim amount of the medical expenses already spent by her. Well, so also she is entitled to receive compensation amount for the pain and suffering and also for the extra transport and physiotherapy. Well, admittedly, the leg was amputated. Well, on all the heads, para 18, your lordship will see, these are the heads which were considered. Well, the one aspect which pain and suffering concern, 18, third, fourth line. However, an amount of rupees 50,000 rupees is awarded. As seen from exhibit A3 to A5, A15, A5, the injuries sustained petitioners are grievous in nature, for which this court cannot compensate the pain and suffering experienced by the petitioner from the date of the accident to the date of healing in terms of money. However, an amount of rupees 50,000 is awarded towards pain and suffering. But this part seeking that pain and suffering is sought for 1 lakh rupees. But the other part is admittedly their salary, which was last drawn salary, but admittedly the salary slip was fine. But your lordship will get in para 11 of the judgment.
Since though the court below found that there is a amputation and disability to the extent of 70%,
yes,
separate compensation was awarded.
Only 90,000 was awarded.
The amputation of a name. Para number?
Para number 12.
Yes.
In his cross-examination, he admitted that exhibited disability certificate is mentioned as not for medical legal cases.
Over in para number 14, the court found that there is a 70% disability and amputation. What more required? Is the amputate? What is the part that was amputated?
The leg was amputated.
Leg.
Yes, left hand.
Exhibit A10 is the disability certificate.
Right leg of the petitioner.
Exhibit A10 is proved and the court also accepted the genuineness. And it is there in the judgment that the disability is 70%. No separate compensation was awarded for that particular injury, disability. Heard both parties. ఇది టీ శ్రీనివాస్ కదా కౌన్సిల్ వాసుదేవ్ రెడ్డి నేను డిలీట్ చేసి అది రాను.
Item 46 and 47, J. Ramakrishna Reddy and Lakkadi Dayakar Reddy.
Case of death. This 20 lakhs, amount granted is 20 lakhs. The insurance company is having 3 grounds, it is in the absence of an income proof.
Quantum.
Yes, quantum. Mainly on quantum. In the absence of an income proof, it's one tribunal took the income of the deceased at 10,000. Secondly, the deceased being a bachelor, instead of 50%, this tribunal has rated 1/3. The third round is that interest rate was awarded 9%, instead of 5%. As far as the
What was the deceased?
He was a mobile repairer. He was a sales executive working in a mobile shop.
Age
22 years. And the date of accident is 13/1/2016. Well, at the last date, he claims that he is earning a sum of rupees 18,000, but the last date has disbelieved this amount. You will also find a paragraph.
Of course, sir. 50% have to have been deducted.
And another ground, 50%, and in case of future prospects, instead of 40%, the loan tribunal added it's a 50%. It should be 40% because it's not a permanent employment. That is one ground. If 10,000 plus 5,000, 50,000 was taken and 1/3 was deducted, ultimately 10,000 was taken and calculated the compensation. But my actual submission was taking 10,000 is excessive and 40% should be applied and 50% should be applied. That is what my submission was. And the loan date, you also kindly see
internal page 13, this starts, that's page number, paragraph, internal page 13 of the judgment, running page 17. To prove the income of the deceased, that he was earning at some of 18,000 per month by working as a sales executive in RX status, Adilabad. The petition filed salary comes service certificate of the deceased late, so the date at February 2016 as exhibit A8. In order to prove the same, they examined the person who issued the certificate as PW3 and the deposit that this worked as a sales executive in the mobile shop at Adilabad from January 2014 to till his death on 14th January 2016. And his last monthly salary paid by the month of December 2015 was 18,000, which includes all the benefits that he issued exhibit A8 certificate based on the office record. The provision of exhibit A8 shows that it was issued on the letterhead of the RS status and as per the deceased worked as sales executive RS status for the last 2 years. Till his death and the last monthly salary paid to the deceased for the month of December 2015 was 18,000. Exhibit A8 also bears the signature of PW3. It is to note that as per the evidence of PW3 and also as per the contents of the A8 certificate, the deceased was working in the firm for the last 2 years. It being the case and the RS status being the firm, certain amounts would have been deducted towards the standard deduction of the deceased, such as PFX. But exhibit A8 admittedly does not show any such particulars, such as bare figures of 18,000 per month, inclusive all benefits. Exhibit A8 does not disclose anything about the benefits which are included in 18,000. As per the PW3 issued exhibit A8 certificate, basing on their office record, but he has not produced any such record on which basis he issued that certificate. Moreover, exhibit A8 certificate does not even disclose the registration number of that firm. It is to be noted that when the deceased worked in that company for 2 years, there must have been some his payroll register showing the monthly salary paid to the deceased till his death, but no such register is filed before this court. It is also to note that PW3 also not filed any document showing that the list total employees earlier worked and presently working in his firm. For all these reasons, and there is no document filed such as pay register showing the payment of rupees 18,000 to the deceased continuously for a period of 1 year or at least for 6 months just prior to his death. And there is the board statement of PW3 that the simple certificate under equity A, which was issued under letter only, which does not even disclose the registration number of the company, cannot be relied upon. And they do not even inspire the creditors, but at the same time, its entire evidence cannot be pressed out. Well, and another aspect, at the material time of accident, the 3 persons was traveling on a motorcycle, and the deceased was a pillion rider, one of the pillion rider. In such circumstances, because no doubt, the accident was occurred from behind, but it's only meant for 2 persons, not for 2 men.
What is the evidence that
yes,
driving?
Your also might be in the cross examination. PW2, the eyewitness admitted the same fact. I was riding the motorcycle.
Full riding is admitted.
Yes.
But
yes, because I was riding the motorcycle and which the deceased was proceeding as a pillion rider at the time of accident. It is true that we were 3 persons traveling in the motorcycle at the time of accident. The complaint was given by one of the relatives. This is not true to say that accident was occurred only due to my rash negligence, riding of the motorcycle, and there was no negligence on the part of the responsible and the driving the individual. The deceased is my friend. He is lived in our locality. But at 3 persons, no driving license. These are another contradictions. It's a violations as to the terms and conditions of the policy. It's now even admittedly, it's taking the income. Your lordship may consider some 8,000 8,000 plus another 40.
Yes, sir. What is
40%? And 50%. That's
even though Court below lordship came to the conclusion that he is entitled for 22,95,000. Lordship, page 24. Page 23, I think. But as we claimed 20 lakhs, lordship was restricted to 20.
What about these things? The bachelor should have been deducted. 1/3 is incorrect.
Lordship, now he is the bachelor and his research fund was depending on his income.
It's settled proportion of law, 50%. In case of bachelor, only 50% shall be deducted. There is no other judgment as on today.
Your lordship, with regard to income, your lordship, HW3 was examined, your lordship, even income certificate has been.
It is very easy to prepare such a pad nowadays.
In a private firm, your lordship.
You could have filed the record. At least a registration number of the firm is not mentioned on the certificate. That was the observation by the court below.
Last week he was 22 years old.
Hired both parties, judgment is.
Yes, sir.
Even this court is taking your 10,000 income, you will not get not more than 15 lakh, 12,000. Plus another fact.
Item 48.
Interest also.
Item 48, J. Rameshwar and Vijay Hasti.
Since October, you are not ready. This is third adjournment, I believe. They also there. Mind you, it is final adjournment. Both are reserved.
Item 49 and 50, C. Mohan Prakash and Annapurna Srila.
49 and 50 both are connected. But actually, in this case, I send the notices. Notices were served. And again, question was sent with the new address. And panel advocate is Satyamanjula is appearing. Your lordship may have chapter 2B. File.
2111.
Yes, please.
Yes.
Parted matters. Item 51 to 53. SL Virendra Singh, S. Srinivas and Manu.
My lord, item 51 and 52, my lord, I am representing the appellant, my lord. I'm sorry, my lord, the court should have been present physically. 51 and 52. 53, my lord, I think my friend senior counsel, Mr. Prabhakar, has started the arguments. Because CCA number 44 of 2009 is connected to 63, my lord. The same arise out of the same judgment, my lord, in invoice number 1 of 2001. And so far 46 of 2009 is concerned, my lord, that is item number 52. My lord, that is against an judgment in invoice number 115 of 2017. My lord, if my friend is continuing, my lord, let him continue, my lord, I am on online. I am appearing for respondent number 3 in my lord OS CCA number 63 of 2023, item 53.
Yes, concluded his arguments on the previous date. On the previous date itself, Mr. Prabhakar concluded his arguments. You may remember us on the previous date, you said you will argue today.
That's correct, my lord. I said he may continue. I am told, I have been instructed that he is continuing. Very well, my lord. Your lordship may see the preliminary objection that I am raising in this appeal, item 53. My lord should see the plaint, my lord, for a moment. Item CCA 63. My lord, see the plaint, my lord, for a moment at page 49. The amended plate at page number 59, my lord should get it. But the suit itself.
Just a minute. Yes.
It's page 59, my lord. This is the amended fair copy that is filed in invoice number 1 of 2001. Parties that have been added. This would be a material because they have to amend the proceedings, not the plaint. The plaintiff is shown as Church of South India Trust Association, represented by General Power of Attorney, so and so. Defendants, my lord, should see, my lord. They want to file a suit for eviction. General Manager, Law Department, Major Hindustan Petroleum. Chief Regional Manager, Hindustan Petroleum. St. Thomas, that is, my lord, I am representing St. Thomas. My lord, the suit ought to have been filed against a corporation. My lords are aware, my lord, after 39, after 29. My lord, it prescribes as how a suit has to be filed by or against a corporation. But general manager is only a post in a corporation. It should be Hindustan Petroleum represented by general manager. The corporation has got it's a juristic person, my lord. Or the 29, my lord, should see for a moment. That has to be amended first. But amendment, my lord, the law is that even at the appellate stage, it can be amended. I've gone through the entire case law and the legal position on this aspect. This amendment is curable. They can do it, but they have to explain. We do not know, my lord, the nature of the post would change. General manager would be reclassified as a vice president in several companies. So therefore, the narration should be, the juristic entity should be a party. That is the Hindustan Petroleum. Irrespective of the whatever the whoever is representing whichever post. Whether it can be nomenclature may change from general manager to vice president, maybe. In some companies, my lord, now they are calling a general manager as a vice president or an assistant director. So Order 29 specifically stipulates that, my lord should see Order 29 CPC mode for a moment. Right, it speaks with regard as to how a suit has to be filed by or against the corporation.
Yes, sir.
Well, 29(1), my lord, so subscription and verification of suits by or against a corporation. The first line itself. This cannot be a suit that is filed against a corporation. This is a suit filed against a general manager in his official capacity. This can be never treated as a plaint filed as against a corporation. Pleading may be signed and verified on behalf of the corporation by the secretary or by the director. Plaint would be signed by the general manager. Suit would be filed against the corporation. My lord, I think I'm clear, my lord.
Yes.
Then my lord should see service of summons also. Subject to any statutory provision regulating service of process where the suit is against a corporation. The summons may be served on the secretary. It's making a distinction, my lord. A corporation, how a suit would be filed. And
why this objection was not taken at the time of trial before the trial court?
That's correct, my lord. It can be taken this objection because this goes to the root of the entire case, my lord. It can be taken at any point of time.
This objection was not raised when the
it was not. I think they have, my lord, they have overlooked, my lord. I'm fairly submitting that they have overlooked. Our side also did not raise objection. The question is now is, my lord, when it is brought to the notice, my lord, the appellant, my lord, should file an application. But this is, my lord, it's like this, my lord. The law on this aspect is that it can be amended at any stage because it's a continuous proceedings, both suit and the appeal. But basing on this description, my lord, this cannot be proceeded with. There's no legal sanctity if this is continued.
Yes.
The reason is, my lord, the facts of the case are originally the property was leased out to Caltex. That is the predecessor in interest, my lord, of the Hindustan Corporation. Then the nomenclature Caltex was converted into Hindustan Petroleum, a new company was incorporated. Then Hindustan Corporation Limited, my lord, it continued on lease and for quite some time. And thereafter, my lord, on an information provided by the appellant, that the Church of South India to the Hindustan Corporation, they enter into a lease agreement with me, which is the subject matter of, my lord, CCA number 46, registered lease agreement, my lord. And in the case of the, my lord, the Hindustan, in the main, my lord should see 115, my lord. 115 for 40, CCA 46, my lord should see. Hindustan Corporation is a party here. So 115, my lord, suit. We have made Hindustan Corporation as a party, not the general manager. That suit rightly, my lord, has been framed. So this issue goes to the root because he says that he is not agreeing to that. He says that we have been, general manager says that we have been informed, saying that the property has been transferred to, my lord, my client, that is the third respondent 63. Then basing on that information, he entered into a fresh lease with us and that was never questioned. And one suit that they have filed, my lord, should see, my lord. Suit OS number.
One.
Well, I'm sorry, no one. OS number.
1 of 2001.
No, not one, my lord. One is subject matter of 63, my lord. Prior to that, the Siesta files a suit, which now, my lord, the matter was carried up to the Supreme Court. It prays for a declaration. It OS 145 of 1997, my lord. OS 145 of 1997. The appellant in, my lord, 63 files a suit seeking a declaration that all the tenants, they have to pay rents to him. That matter went to the Supreme Court. Supreme Court issued notices that is there. But in spite of that, still another suit was filed. That is the subject matter OS number 1 of 2001 after 97 suit. There, my lord, they did not implead me as a party. I went into the suit. I filed an implead petition. I went into the suit as a third defendant. And I brought to the notice of the court, my lord, with regard to the that is subject matter of further here, my lord, arguments with regard to the merits of the judgment, ignoring, my lord, the lease deed and the other suits. And the Supreme Court, when the matter is pending, OS number 145 of 1992, carried up to the Supreme Court. Whether this suit would be hit by the principles of res judicata or not is the question that would arise. The second suit. Because the same relief that is obtained only because in the earlier suit, number of parties were more. I was also a party. Hindustan was also a party. They sought a declaration. Again, my lord, asking for eviction. A suit is filed for a declaration that these people are my tenants, they have to pay rents to me. By the time they have got a cause of action for eviction also. My friend may contend saying that this is a suit for eviction. That is for a declaration that he is the owner. He is the owner and is entitled to receive. At that stage itself, there was a dispute raised because to whom to pay the rents. So the cause of action arose. The action arose for eviction also. Trial court had partly allowed it. It said that the Hindustan is liable to pay rents to the plaintiff, that is siesta. To that extent, it was allowed. But so over the eviction, it said it's premature because your case is not that. You have to issue separate proceedings. Suppose there is a default. Well, that argument, my lord, Hindustan has to argue, but I am bringing to your lordship's notice, my lord.
Okay.
That argument, when in fact, my lord, it would be the appeal. Itself would not be maintainable because on the side of 63 above siesta, because they, so far the declaration is concerned, covered by 145/97.
Item number 51, sir.
Item number 51, my lord, should see. 51 is 44. That is connected to 63, my lord. 52, my lord, should see. 46 for a moment. That is appeal number 11, CCA number 46 of 2 against OS number 115 of 2017. The copy of the judgment, my lord, is at page 9 of that metal papers, my lord. Page 9, my lord, got OS number 115 of 2017. This is filed by me against Hindustan. My lord, this suit was filed basing on the lease document. My lord should get at page 2, Roman letter number 2, paragraph. So internal page 2, my lord, page 10. The running page would be page 10 and internal page 2. Bottom, my lord should see. The defendant executed a fresh lease deed document number 535 of 96, dated 15/7/96 for a period of 15 years from 25/5/1995. My lord's got it, my lord?
Yes.
So this is the basis of the suit, my lord, 115, which I have filed for eviction against Hindustan, saying that there was a violation of the agreement. There is a lease agreement. The case of the Hindustan is that this agreement was executed because Siesta has informed them the properties were transferred in my favor. That is the plaintiff. Therefore, they have entered into this lease agreement. That my lord should get, my lord, at page. That admission, my lord should see. At page 13, my lord should see. Internal page 5. Roman letter 2, my lord, that paragraph I am reading. The Referent Corporation is a central government undertaking statutory incorporated by virtue of take over the central government of the foreign oil companies under the provisions of the Caltex Act 17 of 77. The different corporations catering in refining, storing and marketing of petroleum products such as petrol, diesel, LPG and allied items. The predecessor company of HPCL, Caltex Limited, obtained the site on lease under lease deed dated 30/3/1968 for a period of 10 years. From 25/5/1965, renewable for 10 years from Church of South India Trust Association. That is the appellant in 63, my lord. We are not disputing that. represented by Gordon Shaw. After the expiry of the contractual period, the defendant in letter dated 21/3/1985 sought extension of lease as per the statutory option available under Caltex Takeover Act 77, and the lease was continued from 1985 to 1995. In the month of July 1993, this is very important. In the month of July 1993, the defendant in the letter dated 3/7/1993 was informed that the properties of SPG Tamil Church, that is my client, Lord, the appellant in 46, which were under the management of Siesta, have been transferred to St. Thomas SPG Tamil Church Society, and pursuant of thereof, the extension of the lease term would be transacted by the plaintiff. On 13/7/1993, defendant got issued a legal notice to the plaintiff as well as Siesta. My lord, this is very important. Defendant Hindustan, now it is in a confusion. I am the owner or Siesta is the owner. They issue a legal notice to them. On receipt of the same, the plaintiff got issued a notice dated 12/10/92 threatening for eviction. Consequently, discussions were held between defendant's office and the president of plaintiff. Thereafter, letter dated 19/4/95, the plaintiff agreed to execute a fresh lease deed. Accordingly, lease deed dated 15/7/96 was concluded between the plaintiff and the defendant 15 years initially from 25/5/95. Now the question is, in a suit, my lord, such a case of lessor and lessee, so once the lessee admits that I am the owner, enters into a lease deed, is it open for the lessee to deny my title, my lord? The other party is not there. There is no dispute. They admitted, it got a doubt, still it entered into the agreement. They are bound by the conditions. It's a sharp point in this case, my lord. No, the Church of South India is not a party here. The only defendant is Hindustan Petroleum. But my rights inter se between Hindustan Petroleum are purely governed by the lease deed. But the lessee cannot dispute my title. Once it says, in clarity, it says it had a doubt, but still it has entered into. Now, having entered into, my lord, I stopped from saying that no, I would not say. So that, my lord, that argument, whatever the Hindustan Petroleum Council would be arguing, my lord, I am not aware. He might be advancing the arguments. But my submission is, they cannot raise such a dispute with regard to my title. The court overlooked that, my lords, I'll read subsequently. The court ignored that. My lord should see the Church of South India Trust file, my lord, the next paragraph. On letter 3. Church of South India Trust Association filed suit in OS number 145/97. Again, the plaintiff. This is the suit which I was referring to. Again, the plaintiff and others on the file of the 12th Additional Senior Civil Judge FTC City Civil Court Secunderabad for a declaration contending that the defendant 1 to 5 have no claim in respect of the suit schedule properties, and for a mandatory injunction directed the defendants 8 to 74 to deal with Siesta only in respect of the rents and deposits. But there, the cause of action for Siesta was some of the tenants, including Hindustan Petroleum, because this is filed in 97, my lease deed date is 1996. My lords got it, my lord. The lease deed is 14/7/1996. Hindustan enters a lease deed with me. Then Siesta says, I'll file a suit 145/97, making me a party and the Hindustan as a party, saying that you are liable to pay me, not my client, not my client, the lessor under 97. There itself a cause of action has arisen. He should have filed a suit for eviction because he has deviated from the earlier lease terms inter se between the Caltex claimed by Hindustan and subsequently with the Siesta, till that they were intimated that there was a transfer. Once you defied and there was a violation, alleged violation, there has cause of action has arisen, and that was the reckoning point where a suit for eviction ought to have been filed. But the suit is filed in 2001, which is hit by Order 2 Rule 2 is my submission of the constructive res judicata. A relief ought to have been prayed in OS number 145/97, which has not been prayed, and subsequently OS number 1 of 2001 is filed for eviction. Is hit by the principles of constructive res judicata or the 2 Rule 2. My lords are fully aware of that.
Yes.
Then my lord should see. The first defendant in the OS number 145/97, next line I'm reading, Lord, is the plaintiff herein, as per the orders dated 2/12/2010 in IA number 390 of 97 in OS number 145, defendant also depositing rents from the month of December 2000 to the credit of the said suit. The judgment was pronounced in the said suit and it was held as follows. I hold that the plaintiff Siesta has a right to management over the suit scheduled properties. This issue is answered in favor of the plaintiff Siesta and against the defendant. But this issue is pending before the Supreme Court. But if that 145 says in the Supreme Court tomorrow, well, it says that no, Siesta did not have any right because they have informed that the properties are transferred to the Tamil church and rightly they have entered into lease agreement and the rents were being rightly paid to the Tamil church. Well, Siesta, this is a very purpose of pursuing 63 and 1 would be defeated. Completely would be of non-relevance. They become infructuous. So therefore, when 63 is 63 is concerned, the court has said you proceed against them. So that would be premature to say that order an eviction at least, pending the Supreme Court judgment. So proceeding before the Supreme Court. Then my lord should see. Round letter 4. Siesta has also filed OS number 1 of 2001. This is what 1 of 2001, the subject matter of 63. As per my submission, the same is hit by the principles of constructive res judicata or the 2 rule 2. On the file of first edition Chief Judge City Civil Court against this judgment, defendant for rejectment and for recovery of position arrears of rent. In the said suit, also the plaintiff got impeded as the third respondent. Due to disputes between Siesta and the plaintiff, defendant is being put out to unnecessary hardship, confusion, and forced to fight litigation by spending valuable time and money. As such, defendant filed the OS number 295/2011 before the first junior civil judge. He prayed to dismiss the suit with cause. On the basis of the pleading on the both sides, the following issues have been framed. Then my lord, issues my lord should say. Whether the tenancy was terminated validly, whether the defendant is liable to pay some of to it rent, whether the defendant are liable to pay me from not. These are the issues. These issues were framed rightly within the ambit of a dispute between a lessor and lessee. Now the court traverses completely beyond that while answering these issues. No issue should have been if the court was answering any issue saying that I don't have a right. Then the issue should have been whether the plaintiff has the right to collect the rents or not. That such an issue was not framed. The issues were framed within the ambit of a dispute of a lessor and a lessee. Then my lord should see issue number 1. 106 Transfer of Property Act. Then my lord should see the finding. Page 14. The other factors were taken into account, my lord, with regard to the other pendencies. At page 13, my lord should see, my lord. I'm sorry, my lord. Para 15 onwards. Page 21, my lord. Internal page 13. Para 15. It's further admitted PW1 in his evidence that in OS number 145 for 1997. My lord got it, my lord. 140/19, it was held that the plaintiff Siesta has been managing the property of suit property and the same was not challenged by defendant 1 till now. When itself the plaintiff has no right over the suit property, therefore the alleged termination of the lease by the plaintiff under Exhibit 8 holds no value. But this issue was not framed. The court cannot traverse beyond that. The court has to only see whether I have a right to collect or not. Then my lord should see. As the defendant has been depositing the rent so and so till the disposal of 145 in the court and in view of finding in the said suit, in view of the dispute with regard to the title, did not pay the rents to the plaintiff. Further, as seen from the record immediately after the plaintiff entering into the lease deed, 15/7/96, it seemed that the suit OS 145 was instituted. Subsequently, my lord, this is after the plaintiff, my lord, this is important which I was arguing, my lord. As seen from the record, immediately after the plaintiff entering into lease dated 15/7/96, it seemed that suit 145/91 was instituted. 145 was instituted after 57/96, and therefore 1 of 2001 is hit by principles of res judicata. That was I was submitting, Lord. And subsequently, white number 1 of 2000 was also filed by CS Star, again for eviction. So second cause of action, Lord, this is the crux of the issue to answer that, my Lord, 63. How the entire judgment goes away by the principle of constructive res judicata. Then my Lord should see. Therefore, the plaintiff herein cannot contend that the defendant is a defaulter. Further, since the plaintiff failed to establish the title of the, my Lord, this is important, page 14, para 17. The alleged lease deed entered the plaintiff defendant is not a valid lease agreement. That is not the issue at all. The court holds that, my Lord, page 22, my Lord. Page, internal page 14, para 17. But court cannot traverse, my Lord. Court cannot traverse beyond say that the lease deed is invalid. Because lease deed was there. It is your case saying that I have been informed that properties have been transferred. You enter into lease deed, though you have disputed my right. Subsequently, you say that there was a meeting. I hold that since the lease deed itself is invalid, termination of the lease also invalid. My Lord should see. Since I hold that since the lease deed itself is invalid, the termination of the lease is also invalid. No, these are not the issues that have been framed. Completely traversing beyond the issues that have been framed and the issues between between lessor and lessee relationship. Purely an eviction case. Then issue number 2, in view of the findings and conclusion of the above issue, defendant is not liable to pay sum of so and so. Issue in view of the findings and conclusion of the above issue, so and so.
Yes.
But therefore, my Lord, this judgment is liable to be set aside because there is no issue that has been framed. No issue that has been framed with regard to, and default is admitted. Default, the court says, because your termination is illegal, you don't have a right. The default that is committed by the defendant cannot be treated as a default within the meaning of, for the purpose of eviction, my Lord. That is one of the reasoning that is given. Therefore, this suit completely travels beyond the lower court, completely travels beyond the scope of the suit and came to such a conclusion. In 63, my learned senior is senior friend, Mr. Prabhakar is online. But the Mr. Prabhakar 63, my Lord, learned senior has to answer with regard to the applicability of Order 29. At this stage, whether amendment application has to be filed or not. As my Lord, which I was bringing to your Lordship's notice, my Lord.
Your primary objection is showing the defendant as
general manager, not corporation. My Lord, general manager's nomenclature would be changing. The nomenclature would be changing. My Lord, today he will be general manager, tomorrow he will be vice president, tomorrow he will be a joint director. Nomenclature changes.
And that taken at the time of admission in appeal.
That's correct. Law is that they can amend it. Law is, I am not saying that, my Lord, I am not here for a moment and arguing, saying that, my Lord, contrary to, I have seen, actually, my Lord, I have thoroughly, my Lord, verified, and I am making a submission that it can be filed, but they have to file an application for amendment.
What do you say, Prabhakar?
But I'll just have a look at it, what my friend is pointing out. Lordship may just put it to tomorrow, my Lord. If required, we will file a formal application. That's not a big issue.
You have to say whether the same can be raised at the time of appeal without taking such a plea before the trial court.
But both I'll answer because, first of all, this objection has to be raised by the corporation itself. My friend is not appearing for the corporation. He is only appearing for the private party.
Then I'm already saying that I'm forced to argue for corporation also. I have made that submission already. Because
to the extent of, in a lighter vein, to the extent of saying that he is forced, it's okay, but I only hope that he doesn't ask for further instructions.
No, I will not ask any fee from corporation.
Item number 53 lo heard counsel for the third respondent. In item number 53, you are for third respondent.
Yes,
I am the third respondent, my lord.
and in the first
You are
item,
appellate.
the other items, he is one.
I am the appellant in other two items.
He is the appellant in the other two items.
Continuation tomorrow, sir.
Very well.
God bless me.
For continuation, item 54. P. Venkatamayor and Venkatreddy.
Waiting for the respondent. Questions of law framed by this court in the first one is with regard to whether the court below are justified in determining the issue of partition without framing and deciding an issue as to whether plaintiff is adopted daughter or the said late going to the proper, whether the judgments of court below are vitiated and are liable to be satisfied or not framing. In fact, the lower appellate court has specifically raised this issue. What may kindly see page 10 of the material paper. Lower appellate court judgment.
From where you are reading these substantial questions?
These were framed by the court on 6/3/2007. The first question, Your Honor, when the plaintiff brought the suit for partition, inter alia claiming that she is the adopted daughter.
Right.
What may kindly see page 10 of the lower appellate court judgment. Page 10, paragraph 10, these issues. The first issue is whether the plaintiff is adopted daughter of late going to the father. The lower appellate court has framed that issue and answered negative against it. Therefore, this substantial question of law does not survive or require any further adjudication. Because finding of fact has been recorded by the lower appellate court that no evidence is brought. The option is not true. Now, with regard to the second substantial question of law, the plaintiff is relying on two exhibits, A7 and A8. They are the school certificates which shows the name of the person as father, and based on that, the plaintiff is making a claim that she is the adopted daughter. But those documents, Your Lordship, are not certified copies. Nobody is examined to prove the genuineness of those documents.
They were marked through PW1.
Yes, PW1. In fact, she admits that she did not get those documents. The husband obtained those documents. She did not examine husband. She did not examine the school master, school headmaster. But the suit is originally filed for partition on the basis that she is adoptive daughter of late Boyenpelli Papa. Files the suit is also OS 143 of 2007. The Lordship may kindly see the claim which is at file at page number 42.
Yes.
He claims that she is the daughter, adoptive daughter, paragraph 1. It is to submit that the plaintiff has taken an adoption as daughter by late Boyenpelli Papaya. The late Boyenpelli Papaya has no other legal heirs except the plaintiff. The plaintiff did not plead the fact of giving and taking or the date of ceremony or the date of adoption. Who were present at the adoption? Nothing is brought out in plaintiff. In fact, in the cross-examination, the plaintiff herself admits that this soon scheduled property which she is claiming, 8 acres of land, was already partitioned. And she's confining her claim to only 8 acres. Therefore, the suit for partition does not maintain, in view of her own admission, that there was a prior partition. Without filing a declaration, he cannot maintain a suit for partition. Doctor, may kindly see the evidence of PW1. And this along with additional material papers. was filed on 19th. May kindly come to page 7. This is the cross-examination. Line about 1. This is the line here. I was taken in adoption when I was 11 days old. I was informed by my father, Papaya, adopted father, about the same. There are no documents in proof of adoption. He admits there are.
What was the finding of the trial court about this adoption?
It was negative. She could not prove. Both the courts concurrently held that adoption could not be proved and the suit was dismissed, confirmed in appeal.
Right.
In fact, with regard to the prior partition, you also may kindly come to page 8. 8th line, you know. It is true.
So who is what the defendant? I mean, respondent?
I'm for the respondent. Appellant argued, you know, coming up for the my argument. Page 8, your option, line 8 line. It is true during the lifetime of Papaya itself, suit property was partitioned equally between Papaya and defendant number 1 and 2. Witness adds that they were doing cultivation in joint. I have filed the suit only in respect of property.
So the basis for claiming the property is the alleged adoption, which according to you was not accepted by the trial court. So the other the documents relied on by the plaintiff are 8 and A7.
Yes, those are the school.
You say that they are not proved through the authority.
Yes.
From which it is right.
They are not certified copies.
Third judgment reserved.
So the 3 judgments.
The existing citations.
Item 55 to 57, Mr. Bharadwaj Associates and Mr. Civil B. Ghana.
Paper book in the middle. In the ways of paper book.
Yes.
Yes.
Basically, I just Lordship's notice as to the original suit which was filed by the appellant in SA 620 of 2017 was the suit OS 241 of 98 seeking a relief for specific performance on land adjoining 1607 square meters. But the trial court dismissed the suit in entirety by the judgment of 29th April 2010, against which first appeal was preferred. AS 297 of 2010. But in the first appeal, the first appellate court refused the decree for specific performance for 700 square yards of land, while granting the same for the balance 907 square yards. In view of the same, there are 3 appeals before this honorable court. SA 620 of 2017 is filed by the unsuccessful plaintiff. Partly unsuccessful plaintiff. Part unsuccessful plaintiff.
At least success plaintiff.
Yeah.
By the plaintiff.
By the plaintiff.
Successful by the plaintiff.
By the plaintiff. Where, no, my lord, what happens is why there is also an appeal by the defendants and plaintiff, therefore it becomes relevant. That partly decree was passed. In that context, there is no reason otherwise to. Yeah. Your lordship may kindly see page 163 to 177 of compilation is the appeal filed by the defendants 2, 3, 4, and 5. Sorry, 2, 4, 5, and 6. Insofar as the decree which has been passed for 907 squares. Agreed by this. And the third appeal, my lord, SA 970 of 2017 is filed by one Mr. Motilal Jain, who is a subsequent purchaser of the entire property, 700 as well as 907 square yards, my lord, during the pendency of the appeal. And during the pendency of the present second appeal also, my lord, with the leave of the Honorable Court, he has filed the third appeal. That is how, my lord, 3 appeals are before the Sun. Now, your lordship may kindly appreciate the manner in which originally the claim was made. हाँ मैं दिया हूँ मैं want to मैंने ही दिया पेपर को 25 weeks 20
620 లో కూడా శ్రీనివాస్ 620 లో కూడా పేపర్ బుక్ ఉండొచ్చు.
The paper book which I gave you, I have it only thing is I kept my original copy. Because I gave you correspondence. It doesn't matter, you file a last time.
620 lane mill.
Yes.
All right.
What you could see, what the agreement was originally claimed, what in respect of land in survey number 30, 1607 square yards, and then an early agreement of sale of 1st June 1994 for consideration of 3,05,330. Now, it was claimed as if the entire sale consideration was paid, and in spite of the sale, there was no sale deed being executed. And that is how the plaintiff claims to have approached the trial court for the relief of specific performance. Now, Lordship would kindly see D1 is the original owner of the land. D1 has taken a plea that though according to D1, originally there was an agreement with plaintiff, subsequently plaintiff evinced no interest in the matter, and therefore with knowledge and permission of the plaintiff, according to D1, he had alienated the property. Now, my lord, insofar as defendants 2 to 6 are concerned, the Lordship may kindly see the written statement at page 59 to 62. Lord, 59 to 62 is the written statement by D1. And our written statement, my lord, at page 63 onwards, which was filed by defendant number 5, and which has been subsequently, my lord, adopted by the other defendants by filing a memo, my lord, is the relevant. Lordship may kindly permit me to read this written statement, which would explain, my lord, the manner in which the transaction is progressed. Page 63, my lord.
Yes.
Lord, para 1, line number 3. It would also be totally inequitable to grant the relief of specific performance for an agreement of 1/6/1994 at this length of time, especially since the original suit also was filed in the year 1998 after waiting for 4 long years. Admittedly, the market value of the land in the vicinity of the suit land has been undergone drastic changes during the relevant years, and as such, it would be totally unjust to permit the plaintiff to lay a claim on the basis of alleged agreement of 94 at this length of time. Plaintiff's own conduct also goes to show that she has never been ready and willing to perform her part of the contract, insofar as alleged agreement of 1/6/94 is concerned. As seen from the written statement of D1, in the said agreement was already cancelled, and the plaintiff and her husband have already received consideration for the same. Therefore, viewed from any angle, it would be totally unjust, inequitable to grant any relief for specific performance in the present suit, especially since the plaintiff has also never been in possession of the suit scheduled property for all these years. Without prejudice to the above submissions, it is submitted that the contentions in paras 3 to 6 of the plaint are misconceived and tenable and false. The allegation that the first defendant entered into any such agreement of sale dated 1/6/94 in favor of plaintiff in respect of plaint scheduled property is hereby specifically denied. The allegation that advance of 2,18,000 is paid is also denied as false. The further assertion that the plaintiff later on paid the entire balance consideration on an undisclosed date is also incorrect and false. Admittedly, the plaintiff has not been in possession of the suit scheduled property, and part of the suit scheduled property is in possession of this defendant, he having purchased the same for valuable consideration under registered sale deeds. It is pertinent to note that this defendant has purchased a plot of land at measuring 585 square yards, equivalent to 489 square meters in survey number 30, situated at Upparpalli village, in the Rangalde district, having purchased the same under registered sale deed of 1995, 30th January 1995, bearing document number 380 of 95. This defendant has admittedly been in possession of the said property all along, whereas the defendants 3 to 6 are legal heirs of Prabhakar Rao Bidarkar, who has purchased. Now, from here it becomes a very relevant aspect. Whereas the defendants 3 to 6 are the legal heirs of late Prabhakar Rao Bidarkar, who has purchased 300 square yards of land, equivalent to 250 square meters in the said survey number from K. Vijayalakshmi, under registered sale deed dated 29/6/95, under document number 368 of 95. Another 400 square yards was also purchased by late Prabhakar Rao Bidarkar in survey number 30, under registered sale deed dated 29/6/95. Being document number 367 of 95 from Srimati Aluri Leela, who in turn had purchased the same from defendant number 1 under registered sale deeds, being document number 1295 of 92 and 1294 of 92. Your Lordship may kindly see. So there was admittedly an alienation to my vendors way back in the year 1992 itself, under 1295 of 92 and 1294 of 90. Whereas the alleged agreement of sale is claimed to be of 1st June 1994. The agreement of sale under which the specific performance relief has been claimed, my lord, has been dated 1st June 1994. By the very same D1. So, my lord, there was already a transfer inter vivos under section 54 of the Act, way back in the year 1992 itself. Where was the question of D1 entering into an agreement of sale for adjacent land along with this land also in favor of plaintiff on 1st June 1994. And I am in a position to show, my lord, that my predecessors in title were in possession of the property since the date of purchase since 92. No doubt, my lord, I have purchased in 95. Along with that 700 adjacent square yards of land also from there. But insofar as 400 and 300 square yards are concerned, they were alienated by D1 much prior to the 2 years prior to the alleged agreement of sale. 1st June 94, whereas this is, my lord, in sometime in June 92. The documents have been filed before that. It is therefore apparent that at no point of time the plaintiff has been in possession of the suit scheduled property or any portion thereof. Even otherwise, if the alleged contentions of the plaintiff as to existence of original agreement dated 1/6/94 has to be taken into consideration, the same has been cancelled as explained by D1. The allegation as to D1 having received the entire sale consideration is also false. The allegation that the plaintiff has been in possession and constructed a room in the suit site is also incorrect and false. The plaintiff is admittedly relying upon the fictitious document, and the contentions raised in this respect are hereby specifically denied. At any rate, it is submitted that the payment of such taxes at convenient time by the plaintiff cannot clothe him to claim entitlement of a decree for specific performance or for possession as arranged. The allegations as to demand of execution of sale deed in the first week of April 98 and D1 not cooperating with the plaintiff are merely apparently being made for the sake of maintaining the suit for specific performance. Vague and ambiguous allegations have been made and so on. Now, my lord, this has been the basic contention of the contesting defendants. Now, my lord, keeping this, now let us see, my lord, the written statement of D1. In fact, prior to that, my lord, it would be also interesting to see the amended plaint at page 54 and as to the manner in which the plaintiff approaches the court. page 55, para 3. The first dependent hearing was the absolute owner and possessor of suit plot in serial number 30 at measuring 1607 square, so and so. The first dependent has sold the suit plot in favor of plaintiff under agreement of sale dated 1/6/94 for total consideration of 3,05,000, of which the defendant has received a sum of rupees so and so on the date of agreement. Subsequently, the plaintiff has paid entire balance sale consideration amount and the defendant has acknowledged the receipts of the same, white separate receipts. The last payment towards sale consideration amount was made by the plaintiff to the defendant on 1/9/94. Having received, Lordship, I kindly see, now 1st September 94 is the last date of payment by the plaintiff to D1 at page 55. So why should he wait then for the filing of the suit, my lord, in the year 1998? He filed the suit, my lord, on 30th April 1998. More than 3 years. Having received the entire consideration amount, the defendant has delivered possession of the suit plot to the plaintiff. In fact, the husband of the plaintiff was appointed as the general power of attorney of defendant who had registered document. As the defendant has received the entire consideration amount and the defendant has appointed the husband of plaintiff as general power of attorney, there was mutual trust and confidence between parties, and as a result of the same, the defendant has delivered possession of the suit plot to the plaintiff, and thereafter the plaintiff has constructed a room in the suit plot, and the same was assessed to property tax by Rajan Nagar municipality, having granted the house number so and so. The plaintiff has been paying property tax. Now, my lord, pausing here for a moment. My lord, there is no specific assertion or a document showing as to on what date the alleged possession of the property was delivered. Secondly, a very strange thing, my lord, in this case is that the appellant claims that there was a registered power of attorney executed in favor of her husband by D1. And you claim to have paid the entire amount by 1st September 94. Why you don't obtain a sale deed in your favor? And where is the explanation for not doing so? And where is the document or date of delivery of possession? The plaintiff and her husband approached the defendant in the first week of April 98 and requested the defendant to execute sale deed in favor of the plaintiff in respect of the suit schedule plot. As per the terms and conditions of the agreement of sale, the defendant has developed non-cooperation against the husband of plaintiff, and therefore the plaintiff has not fit to take sale deed in respect of the suit plot from the defendant. Defendant has postponed the execution of sale deed by 1 week in the first week of April 98, and thereafter the defendant has not been responding to the request of the plaintiff to execute the sale deed in favor of plaintiff. Plaintiff has reliably learned that the defendant is taking active steps to alienate the suit plot to third parties. The plaintiff has reliable information to the effect that defendant is not abiding himself with the suit agreement of sale. It is submitted that the plaintiff has always been ready and willing to perform her part of the obligation under the suit agreement of sale. In fact, the plaintiff has paid entire sale consideration amount to the defendant. The plaintiff is ready and willing to bear necessary expenditure for obtaining sale deed from the defendant in respect of the suit plot in terms of the suit agreement of sale. Defendant has developed unwarranted indifference insofar as compliance of the suit agreement of sale is concerned, and thus the plaintiff is constrained to file present suit for cessation. Very, very, very strange circumstances. In one breath, they say there is a registered power of attorney executed in his favor. Another breath, they say that for 1st June 94, just 2 minutes, for 1st September 94 itself, the entire amount is paid. They say on an undisclosed date, the possession is delivered. Then why you did not obtain a sale deed in your favor? Well, my respectful submission would be a meaningful examination of this plaint would show that there is something left desired in this plaint because of obvious reasons, as were explained by him in his interest.
It will continue at 2:30, sir.
Saying that he will appear on live.
One by one, at least for my convenience.
Item 16, accommodate me for 14.
Who are not ready for the past 4 or 5 agendas.
It's only to compile the citation.
I agree, he's there.
Except 1498, Virat. Except 1498.
15?
Yes, sir.
Item 60 at request of respondent. 15.
15. Item number 58, Virat. 16.
16, huh?
15th of the case. 15th. 16. Item number 58, Virat. I have the last submission I submitted, that I will file a paper book. I have filed the paper book, but there are 3 letters in Rajasthani. We have to get them translated. My last may have it tomorrow. Senior counsel.
Other sir, Mandani.
Tomorrow it may be taken. I will file the paper.
Tomorrow, sir? At request of respondent. Tomorrow.
Tomorrow, early discuss because afterwards I will.
Worship item 59, Worship.
Sir.
We take up this matter after Worship. In this matter, we are engaging senior counsel. It's not correct. In this matter, we are engaging senior counsel. We have informed other side, they don't have any objection.
Mandani karega.
And for 59,
59, other side Mandani karega.
59.
No, he left. Whom you have informed? Who is the other side?
Counsel, we have informed.
He is the petitioner's counsel, Mandani. Just now he left. All right. Request of respondent.
59, Worship.
Epudamma?
2 weeks.
21/11.
Item 61. 61 for my country. Documents are slow. Submitted by my land fund are lost. Next submission.
61 tomorrow.
Tomorrow.
59 and మళ్ళీ చెప్తాడు.
it will answer. So you may kindly see the plaint is at page 54. We are just now seeing the plaint, para 3 and 4, right? Lordship may kindly see. Now the relevant thing would be the written statement of D1. It is at page 59. But at the outset, the defendant humbly submits that the plaintiff has filed a false, frivolous, misconceived, and speculative suit with malafide intentions and ulterior motives by cross misrepresentation and suppression of material facts. Therefore, the defendant hereby deny all adverse material allegations set up in the plaint and reply in their entirety, except those ones. The defendant humbly submits that the suit as framed is not maintainable either in law or on facts, and it is hopelessly time-barred. There is no subsisting contract between the parties as on the date of institution of the suit. As such, the suit for specific performance is misconceived and marginal. Then, in reply to para 3 of the plaint, it is true that the defendant was the absolute owner of and possessor of suit plot number 30 at 1607 square yards, situated at Upperpalli village, Rajanagar Mandal, Aradi district. It is denied that the defendant has delivered possession of the said property to the plaintiff. Lordship may kindly see this is important. And that the defendant has not been coming forward to execute sale deed in spite of her willingness to perform her part of the contract. The defendant further denied that the plaintiff has constructed a room in the suit plot and assessed to property tax and granted house number to the construction made on the plot. The defendant never delivered possession to the plaintiff. Therefore, the question of construction of room does not arise. It is a concocted story. The defendant submit that one P. Narsaya, resident of Upperpalli, is a close relative of plaintiff Erin, though through her husband. And her husband's brother's daughter given in marriage to the son of Narsaya alias Narsimha. At the instance of the said Narsimha, the defendant has entered into suit agreement of sale with plaintiff in respect of suit property, agreeing to sell the same to the plaintiff for total sale consideration, so and so. The defendant has also executed a registered GPA in favor of in the name of the husband of the plaintiff. The possession of the suit property was to be delivered to the plaintiff at the time of conveying the suit property through registered sale deed. Meanwhile, the plaintiff, through her above named relative P. Narsimha, who transacted the said transactions, informed the defendant that the plaintiff is desirous of resigning from the sale transaction and therefore intimated the defendant to choose any other prospective buyer. Accordingly, with the consent of the plaintiff and her relative Narsimha and their knowledge, the defendant has sold and conveyed the suit property to one Vinayak Rao through registered sale deed 3 years prior to the execution of the above suit and delivered possession of the same to him. The defendant submits that the said Narsimha and her husband Shankar, representing the plaintiff, agreed to receive 5,50,000 from the defendant towards cancellation of the suit sale agreement, and in lieu of the consideration paid pursuant to it, as per the said agreement and understanding, the defendant has paid a sum of rupees so and so to the plaintiff through the said Narsimha by way of cash, and for balance 1 lakh rupees at the instance of defendant, his brother-in-law V. Narayan Reddy issued a check so and so. The said Narsimha, having received the same, acknowledged receipt through receipt dated so and so, and promised to surrender and return the original agreement of sale and other documents such as receipts to me on realization of the sales. Thus, the said suit agreement of sale stood cancelled with mutual agreement in the manner referred above, and the defendant has conveyed the suit property to third party with the knowledge of the plaintiff, her husband, and the above referred relative who was instrumental in the suit transaction. By the time the suit is laid by the plaintiff in the year 98, the suit agreement of sale was not in force and it stood resigned. Lordship may kindly see on this count, he sought for dismissal of the suit. Now, my lord, this defendant number 1, admittedly, my lord, did not participate during the trial of the suit. Now, on these pleadings, my lord, the trial court had framed whether the suit claim is barred.
What happened to the agreement that was?
I'll show that. Next thing, I just want to, after showing the issues, okay, whether the suit claim is barred by limitation, whether the plaintiff is entitled for specific performance of agreement of sale, whether the plaintiff is entitled for perpetual injunction restraining defendant from interfering with possession of the suitable property, whether the plaintiff is entitled for perpetual injunction restraining the defendant from alienating the suitable property. Should may kindly see the exhibit A1 is the agreement at page 97. Our case also is that this D1 is in collision with plaintiff. in convenient collusion. So no doubt he filed written statement, thereafter he conveniently absents himself. There is one more thing, my lord, is A1 is not signed by the plaintiff. Your Lordship may kindly see. Very peculiar document. It is not signed by the plaintiff. No signature of us. Now let us see the document, my lord, page 97. P. Narasimha Reddy, so and so, Jamuna Bai, Vendi. Whereas the vendor herein is the absolute owner and peaceful possessor, so and so. And whereas the vendor hereby agreed and offered to sell the said property to the vendee for a total sale consideration of so and so. Then, in pursuance of the said sale consideration of so and so, the vendor has already received a sum of rupees 2,18,000 from the vendee in various dates, and vendor hereby admit and acknowledge the receipt of the said sum of 2,18,000 to the vendee. Now, my lord, pausing here for a minute, I have evidence to show by registered sale deeds. Already 700 square yards was alienated way back in 92 itself. This agreement is of June 94. Now, my lord, therefore, my respectful submission would be D1 and plaintiff are in collusion with each other. They created some kind of a transaction on the basis of this document and they want to rely upon the same. Then naturally D1 would not be in a position to face the situation or whatever it is, better he doesn't appear. So after filing a pleading, admitting about the alleged agreement and denying about the balance sale consideration, he absents himself. The purport of D1's written statement is, he says there was an agreement. And he says that however balance consideration was not paid. And he absents himself. Now my case is that way back out of this 1607 square yards, 700 square yards was already alienated by D1 way back in 92. I approved it by filing the registered sale deeds. And I'm in a position to lay before the Honorable Court. The law is a settled one. The Honorable Court is aware. Section 3 of the Transfer of Property Act, read with Section 3 of the Registration Act. A registered sale deed is there. You cannot claim ignorance about the same. There is a situation of deemed notice. Our Honorable High Court and Honorable Supreme Court has time and again come forward on, rather has laid down and reiterated the law in this. Now let us read further that the vendee hereby further agreed to pay balance sale consideration of rupees 87,330 to the vendor in full or parts on or before 90 days. So this is crucial. 90 days, that is within 3 months from this day, and the vendor hereby agreed to sale. The time is stipulated as to within what time you have to pay the balance. Whereas the vendor hereby assures the vendee the scheduled property is free from all kinds of encumbrances, charges, sales, gifts, and other attachments. And whereas the vendor hereby assures the vendee he is absolute owner, vendor hereby executed, Lordship, page 99, vendor hereby executed a GPA in the name of T. Shankar to complete the transaction and to execute the sale deed or sale deeds in favor of vendee or her nominee or nominees. Whereas the vendor further covenant with the vendee, that is, the vendor is deprived of the whole or any part of so and so due to defect, further agreed to sign all such papers. So, Lordship may kindly see the GPA. Also, my lord, is part of the record at page 113. So, these are registered GPA. Page 113. Yeah.
Yes.
Yes, no all men, I, P. Narasimha Reddy, so and so, do hereby nominate, appoint, and constitute T. Shankar, son of late T. Balaya, resident of the I am the absolute owner and pattedar, peaceful possessor of open plot in survey number so and so, at within 1607 square yards, that due to various avocations and preoccupations, the executant not able to supervise and manage the said property and the executant hereby appointed above named attorney. The attorney hereby authorized to sell the said property on executant's behalf to any other person whomsoever or attorneys right without typing mistake and execute sale deed like probably or attorneys like and execute the sale deed and register the same on executant's behalf, to sign and execute all documents for executant and in executant's name and to present the same for registration before registry or sub-registry office there to admit execution, etc. and to do all necessary acts in such connection to appoint advocate so and so. Generally for executant, execution as per executant act and deed to do all acts, deeds and things so and so. To receive consideration amounts and grant proper receipts on behalf of execution and to render accounts for executed, and the attorney hereby authorized to develop the said property or construct so and so. Now, when exhibit A24 is in place, the question which I asked to myself, my lord, is, you have an agreement of sale. Actually, you have your vendor has already sold a part of that property under registered sale deeds earlier itself. Registered sale deeds earlier itself, who are in possession of the property. Agreement of sale A1 does not mention anything about delivery of possession. The power of attorney given, my lord, on the same day, 1st June. That is that page. Lordship may kindly see on the same day. Agreement of sale is on the same day, power of attorney is on the same day. When does this happen normally? Your Honor, it happens in money lending transactions. These kind of things. Now, if really there was an agreement for sale, my lord, who stopped them? Their exhibit A24 was with them, and they could have simply gone in their favor. They knew that a part of the property was already alienated in 92 and thereafter in 95. So they took a chance by filing this suit in 1998. Lordship recollects, my lord, under exhibit A1, under the first clause at page 98, the time stipulated is 90 days. Article 54 of Limitation Act is crystal clear. My lord, what does it say? It says that when there is a stipulation as to time, within 3 years therefrom, no stipulation within 3 years from the date of refusal. That is the law. That is the basic law of the land. Now here, my lord, your lordship may kindly see the present suit itself was filed. Page 54. The suit itself was filed on 4th July 2008. The lordship may also kindly see the original plaint at page 54. How they wanted to take a chance, page 54. My lord, they filed the suit only against D1 originally. There were 4 sale deeds already in place. There are 2 executed in 92 and the subsequent alienations in 95. 5 sale deeds were their registered sale deeds. They did not make the purchasers as parties. Lord, decrets 2 to 6 were added as per the implicit petition order on 3rd July 2008. Therefore, what I would say, my lord, is exhibit A1 agreement was apparently maybe some kind of a money transaction between them or a creation of the document. And they cannot claim ignorance about, even as on the date of A1, they cannot claim ignorance about the documents already executed in 92. But you may kindly see page 117. That is exhibit B2 and B3. But you may kindly see B2 at page 117. It's the registered sale deed by same Narasimha Reddy so and so to Alluri Leela. And the next one, my lord, at page 125, 126 is the sale deed commencement in favor of Vijay Lakshmi. The first one, Your Honor, is the first one, my lord, is for 400 square yards. Second one is for 300 square yards. And these purchasers in turn, my lord, have alienated the property further under exhibit B4, Prabhakar Rao Bidharkar, again under registered sale deed in 95. B5, your lordship may kindly see. Again, on 2nd June 1995, these 2 sale deeds in favor of Prabhakar Rao Bidharkar. First one is for 400 square yards. The second one, again, my lord, is for that 300 square yards. Then B6, my lord, is by Demon himself at page 151. That is also of this day, June 1995, at page 151 in favor of Venkatesh. Now, my lord, this Venkatesh is defendant number 2. So this, my lord, is in respect of 585 square yards. That is how, my lord, the property already stood alienated. And ultimately what has happened, your lordship may kindly see, is the appellant in SA 970 of 2017, along with the leave petition, he has filed documents. He has purchased the entire extent from us as well as from them. And that is how he has become the owner of the property. Now, my lord, in place of all these registered documents which were there on record, and when Exhibit A1 already stipulated as to time being essential of the fund, as to you have to pay the balance consideration within the stipulated time as under Exhibit A1. Well, Lord, they cannot stretch filing of the suit in such manner to the year 2008, beyond 98. 98. So, no, 98. I'm sorry. 98. 1694 is the document, and within 30 days, my lord, they were supposed to pay the amount, which they did not pay. And, they can't. Within 90 days from 1694, well, it would be to June, July, August. So from 1st September, they ought to have paid the money. So 1st September 94 to 1st September 97. A suit has been filed in, my lord, as I have pointed out, in originally filed, my lord, in 379.
The amended.
3 would show. Yes, 30th April 98. Lord, any which way we look at it, Lord, it was filed much beyond the period of limitation as including. Number 1. Number 2, your lordship may also kindly see the evidence of PW1 and PW2 is crucial in this respect, especially the cross examination. But I would maybe permitted to read the same. PW1, my lord, is the husband. Jamunabai's husband. Lord, it starts at page 66. 66 is the chief affidavit. The cross examination is at page 69. Yeah, page 69, the bottom portion. There is no, rather we can go to 70. I have studied up to 4th class in Telugu medium. I am a civil contractor and I am an IT SSC. My wife, plaintiff, is an illiterate. She is a housewife. The no source of income. Our plaintiff has no source of income on her own. The plaintiff and is IT assessee for 3 years. At this juncture, the Learned Counsel for Defendants 226 raised objection according to Exhibit A1 that it is insufficiently stamped and it cannot be looked into. The court rules that the objection can be raised at the time of final arguments. Subject to the objection, the counsel is directed to cross-examine the witness and it will be considered at the time of final arguments. I don't know whether Exhibit A1 is not sufficiently stamped. I cannot say whether there is no recital about delivery of possession the plaintiff is by the plaintiff in Exhibit A1. We did not file any other document to show that the possession was given to the plaintiff. I do not know whether there was no mention about delivery of possession in the plaintiff in favor of the plaintiff. Exhibit A1 does not contain the averment as to, I don't know, plaintiff and all. Exhibit A1 is not registered document. Today I see the GPA filed by me, which is executed by Narasimha Reddy in my favor, dated 1694. It is marked as Exhibit A24. I don't know whether there is no recital in Exhibit A24 about delivery of possession of property and to deliver possession by me to prospective purchasers. I don't know whether the The possession of the plaintiff mentioned in the plaint, we did not obtain permission from municipality for construction of compound wall. I did not mention the amount spent for construction of compound wall in the plaint. It is not true to say that the suit property does not stand in the name of plaintiff in any of the records and that exhibit A 21 and 22 are falsely created. I have not obtained NOC from D1 for mutation in municipal records in the name of plaintiff. I don't know as to which document is produced before municipality to affect mutation in the name of plaintiff. Lordship may kindly see, they have produced some receipts and the first appellate court relies upon the same. Lordship, there was a power of attorney under exhibit A24 executed in favor of PW1. Later on, he admits that in persons of that he obtained a mutation, not in persons of delivery of possession. As the next continuation, as on the date of exhibit A21, there was no sale deed in favor of plaintiff. As on today, there is no sale deed executed in favor of plaintiff. The basis for effecting mutation under A24 is only the GPA by D1 in my favor. I do not know whether A24 does not authorize me for mutation of the property, either in my name or in the name of the plaintiff. Except GPA under A24, I have no other document to show that possession is delivered to the plaintiff. I had not given any notice to D1 prior to filing of this case. This is crucial. Under exhibit A24, I am authorized to execute sale deed on behalf of D1. I cannot say the reason for filing suit against D1 asking for specific performance. The witness volunteers that he does not know the technicalities. But holding a registered power of attorney, it's not a technicality. I do not know whether there is no mention about the execution of agreement of sale in favor of D1 and that I am given absolute power to develop the land and to sell and receive the sale proceeds for purchases. The agreement was executed in favor of plaintiff by D1 in 94, but I cannot say the date of such agreement. I do not know whether D1 sold away 300 square yards in favor of R. Vijay Lakshmi on 31/1/92 under registered sale deeds. I do not know whether D1 sold 400 square yards on the same day in favor of Leela. I do not know whether Vijay Lakshmi and Leela had sold the property purchased from D1 in favor of Prabhakar Rao on 29/6/95 and that Prabhakar Rao, her husband of D3 and father of D4 to D6. I do not know whether D1 sold 585 square yards in favor of D2 under registered sale deeds dated 30/6/95. Prior to filing of this case, the property was standing in the name of Narasimha Reddy as per my inquiry. I had not filed any document to show that the property is standing in the name of Narasimha Reddy. I do not know whether D1 was trying to alienate the property in favor of third parties. I do not remember whether plaintiff mentioned in the plaint that D1 is trying to alienate the property in favor of third parties. I gave instructions to draft the plaint. I do not know whether there is a difference in handwriting over the stamp at purchasers column in A1 and A24, though they are purchased from one stamp vendor and on the same day. My wife had not signed the agreement of sale under Exhibit A1. It is not true to say Exhibit A1 is falsely created by me in collusion with D1, and that for the same reason A1 does not bear the signatures of the plaintiff. Then he has denied the suggestions that are given by us as to the enforceability of the contract. Your Lordship, the plaintiff herself was examined as PW. Her cross-examination is at page 76. The witness has filed affidavit in lieu of so and so, and I am a housewife. I studied up to third class. I have no source of income. I do not know the defendant number one. Witness acts, I have seen him once. I am not an income tax assessee. I do not know English. I do not know the contents of A1. A1 does not contain my signature. It is true there is no covenant in A1 about delivery of possession to me. I have not filed any document to show that possession of suit scheduled property was delivered to me. I cannot read the contents of A24. I cannot say the contents of Exhibit A24. It is true that there is no power to my husband to deliver possession of suit scheduled property to anybody. Exhibit A1 has been got tied by my husband. I am not aware about Exhibit A1. I do not know the contents of A2 to A20. I don't remember the date when the possession of suit property was delivered to me and by whom. I got drafted the plaint and I cannot say the contents of the plaint. I have not affixed the signatures on pages 1, 2, and 3 of plaint. Lordship, may kindly. I got drafted the plaint. I cannot say the contents of the plaint. I have not affixed. I have not affixed the signatures on page 1 to 3 of the plate. It is true that there is no mention of delivery of possession to me in plate. I have not taken permission for construction of a room and a compound wall from the municipal authorities. Witness has, as neighbors informed me to construct, I constructed. I cannot say who got drafted my evidence affidavit. There is no sale deed in my name in respect of suit scheduled property. I cannot say on basis of which document the property has been mutated in municipal records. Witness adds, my husband knows it. PW1, I have not got issued any notice to D1 prior to filing of this case. I cannot say the time stipulated in Exhibit A1. We have not issued any notice calling upon D1 to execute and register sale deed in my name in respect of suit scheduled property. I don't know on whose name the suit scheduled property stands as on the date of filing of the suit. It is not true to suggest that as on the date of filing of the suit, the property is in the name of D2 to D6 and not D1. In the year 1998, I came to know that D1 is trying to alienate the property. I have not issued any public notice or paper publication informing the general public about the transaction. I cannot remember on which day D1 tried to interfere in my possession in respect of suit scheduled property. I do not know whether D1 sold land at measuring 400 square yards to one Leela, 300 square yards to Vijay Lakshmi on 30th January 92 under registered sale deeds. It is not true to suggest that D1 has no right to sell the property to me. It is not true to suggest that my husband and D1 in collision has created Exhibit A1 to defeat the rights of D2 to D6 in order to grab the suit scheduled property. It is not true to suggest that possession was never delivered to me, and it is not true that the defendant number 2, 6 are in possession. Then, my lord, she denied the other search. Lord, in addition to this, they also examined one more witness as PW3. His evidence is of no consequence, my lord. He just claims to be acquaintance of theirs. So, Lord, in these circumstances, but the trial court, in fact, rightly dismissed the suit, my lord, as it was filed. So, Lord, insofar as the first appellate court is concerned, Lordship would see that while considering in a suit for basic performance in such circumstances is concerned, Lord, it is necessary for the plaintiff to show his readiness and willingness. Now, Lord, D1 has not been examined. He did not come before the court to speak about the unleased agreement Exhibit A1. Exhibit A1, if your lordship may kindly permit me, my lord, it suffers with situations as to, my lord, it is not signed by D1. It is A1 does not contain signature of D1. My lord, there is no averment as to delivery of possession. There is a specific stipulation as to 90 days payment to be made for balance consideration before 1st September 94, which is conveniently suppressed in the plate. And my lord, in such a circumstance, under Article 54 of the Limitation Act, the suit, if at all it was to be filed, it ought to have been filed, my lord, by 1st of September 97, which has not been filed. And there is no explanation as to otherwise to extend the time or otherwise in this case. Your lordship may also kindly see even the subsequent alleged receipts, my lord, under exhibits A1, A2 to A23, they also do not contain any averment as to delivery of possession of the property. My lord, we have come across many such transactions where under the original agreement of sale, possession might not have been delivered, but it might have been delivered subsequently while acting upon the agreement. Even that situation, my lord, is absent here. There is no document of delivery of possession. Even the power of attorney, my lord, which is produced, my lord, it doesn't speak of delivery of possession, and it is strange that in spite of there being a power of attorney, registered power of attorney in favor of in the hands of plaintiff's husband, that is PW1, she does not go ahead and get a sale deed executed in her favor. Now, my lord, insofar as such situations are concerned, my lord, I would say that the plaint in this case, my lord, let us go once again back, my lord, to the plaint at page 54. . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . Not at page para 4, at page 56. The defendant has developed non-cooperation. Under the para 4, the plaintiff and her husband approached the defendant in the first week of April 98 and requested the defendant to execute sale deed in favor of plaintiff. So that is beyond the period itself. And it requested the defendant to execute sale deed in favor of plaintiff in respect of suit schedule plot as per the terms and conditions of the suit agreement of sale. The defendant has developed non-cooperation against the husband of the plaintiff, and therefore the plaintiff has not fit to take sale deed in respect of suit plot from the defendant. The defendant has postponed execution of sale deed by 1 week. That is first week of April 98, and thereafter the defendant has not been responding to the request of plaintiff, and therefore, my lord, they say that they came to the court the 30th April 98. My lord, this is the alleged oral demand. Lordship would see that as required under section 16C of the Specific Relief Act, my lord, they ought to have issued a notice explaining their readiness and willingness. My lord, insofar as Lordship may kindly see para 16 of the judgment. Para 16, my lord, at page 208. Yes. Reading form numbers 47 and 48 of CPC together with section 16C of the Specific Relief Act, it has to be held that ordinarily requirement of law is issuance of a registered notice by plaintiff demanding the accepting of balance sale consideration and execution of sale deed by the vendor. First defendant. Section 16C of the Specific Relief Act lays down that the plaintiff has to aver and prove that he has performed or has always been ready and willing to perform his part of the contract. The contract for sale of immovable property has to be performed by the buyer in accordance with so and so, section so and so that. Section 55 of the Transfer of Property Act contains the rights and liabilities of the buyer and seller. Section 55 1D of the TP Act lays down that seller is bound to execute proper conveyance of the property when the buyer tenders the amount due in respect of the price at a proper time and place. Section 55 5B of the Transfer of Property is to effect that buyer is bound to pay at the time of place of completing the sale. The execution of conveyance deed as a duty of the seller and as a right of buyer has a commonality with reference to time and place of completing the transaction. There cannot be better evidence of showing compliance with these provisions than the buyer sending a registered notice to the seller demanding execution of conveyance. Indeed, this conclusion is supported by law laid down by Honorable Supreme Court. This could, however, so much. And what para 17 also, your lordship may kindly see, exception is established. This court, however, essays to add that in law, oral demand by the buyer of immovable property, as such being sufficient compliance, cannot be totally ruled out. In such circumstances, proof of oral demand should be strong and unimpeachable, and mere allegation that too in a passing manner would not be sufficient compliance. So, my lord, my respectful submission here is, my lord, that's why I pointed out, my lord, para 4 of the plaint. And as to, my lordship, if I am a bona fide plaintiff, I will explain that 1694, I had agreed to pay balance sale consideration within so and so days. Thereafter, it was paid on so and so days. Thereafter, whatever has happened, your lordship, the plaint is as cryptic as it can be. And there is no compliance of the basic rules of law in this respect. So, my lord, it would be totally unjust to believe the mere ipse dixit of the plaintiff here and to award them with a relief of specific performance, as was attempted to by the first appellate court for part of the land. So, my lord, in addition to this, your lordship may kindly see the page 2. Page 2, page 750.
56, 57, I can know.
Ah. Should may kindly see para 23 of the judgment. So basically, I am giving the judgment only for the honorable court to consider one thing. That my lord, in a suit for basic performance, even in a given case, if the agreement, existence of agreement is admitted, my lord, that doesn't mean that a degree for basic performance would follow. Only for that proposition, I have given the judgment, my lord, to explain that all the other attending circumstances as to readiness and willingness, as to the factor of the plaintiff, whether he deserves the relief, whether he has come within time, and especially in a circumstance, my lord, like in our case, my lord, admittedly there are registered sale deeds executed. Prior, not only 2 registered sale deeds for 700 square yards of land prior to the agreement of sale itself, and subsequent to the alleged agreement of sale, my lord, prior to the filing of the suit. Now, my lord, I also pass on the Veer Brahma. One more judgment is, my lord, 2008 5 AD, page 571. Only insofar as the bona fides of the parties would be very much relevant in such circumstance, while considering the case of the plaintiff. My lord, here there is a situation. Please give me the. Insofar as the deemed notice under section 3 of the Transfer of Property Act and the Registration Act is concerned, Lord, I am passing on these 3 judgments of our Honorable High Court. Yeah. Sorry. Please. The first one is Jambula Ganesh Reddy versus Jambula Anjan Reddy. We can come to para 31. Para 28. Yes, para 26 onwards, I'll read that. Srinivas so and so, counsel appearing for respond number 10 to 12, disputed the said petitions and supported the order passed by the court. He also pointed out that the transactions under P2 to P6 are registered transactions, and as per explanation 1 to section 3 of Indian Registration Act 1908, registration of a document is constructive notice, and the appellant cannot plead ignorance of transactions which took place in 1988. He relied upon the decisions in Hyderabad Cooperative Urban Bank Limited, Hyderabad, represented by person in charge Manoj Kumar Naligar versus Andhra Pradesh Cooperative Hyderabad, represented by Chairman, then Veena Muralidhar Hemdev, Honorable Supreme Court Judgment, then Janardhan Prasad versus Ramdev, Honorable Supreme Court Judgment, and Shakuntalamma, KV Govindswamy and others, a judgment of our Honorable. We may point out that that the suit schedule lands are located in Dasarpalli village and the appellant admittedly resides in the same village. Exhibit P2 registered sale deed dated 4/6/88 was executed by Yadgir Reddy, the husband of second respondent and third respondent together, in favor of respondent number 4 and 5, in respect of so and so acres, so and so. Likewise, P3 registered sale deed was executed by first respondent in favor of fourth respondent, in respect of 2 acres 20 acres in Satyavan. Respondents 4 to 9 executed exhibit P5, registered sale on 8/1/2007 in favor of 10th respondent. Exhibit P6 sale deed also on 8/1/2007 in favor of 10th respondent. And these two sale deeds cover the entire suit schedule property. All these transactions are registered under Registration Act 1900. Under Section 3 of Transfer of Property Act, a person is deemed to have notice of a fact when he actually knows that fact, or when, but for willful abstention from an inquiry or search which he ought to have made, or gross negligence, he would have known it. Explanation 1 thereof says, where any transaction relating to movable property is required by law to be or has been affected by registered instrument, any person acquiring such property or any part thereof or shares or interest in such property shall be deemed to have notice of such instrument as from the date of registration. In Janardhan Prasad Supra, Supreme Court adverted to the explanation 1 to Section 3 of Transport Property Act and observed that the registration of a document is deemed to be constructive notice, and possession would also be constructive notice as per explanation 2. Reiterated in Bina Hemdev's case. My Lord, Bina Hemdev is also a judgment of Honorable Supreme Court. My Lord, in Manu /AC/0386 from 1999. Now the rectification deed is a registered document. The agreement by the Sanklas with the builder is dated 16/7/94 and it specifically refers to the deed of rectification. The Giants agreement of sale dated 19/8/94 with the builder no doubt omits to refer to the rectification deed and says that there are only some claims of Lokras, but the Sanklas were obviously more truthful. Now, if the agreement of Sanklas had put the builder to notice of the rectification deed specifically, as stated earlier, it is prima facie clear that the builder has actual notice and was obliged to inquire into details. Thus, there is actual notice. There is also constructive notice in as much as rectification deed is a registered deed and Section 3 expansion. In as much as the rectification deed is a registered deed, it is deemed to be noticed to the builder in view of Section 3 of the Transfer of Property Act. I have also taken a similar view in Hyderabad Cooperative Urban Bank case. Limited case Sutra. In Shakuntalama, I have followed the decisions of Janardhan Prasad and Hyderabad Cooperative Urban Bank and held that when there is a registered deed, there is a constructive notice of it as per explanation 1 to subsection 3 of the registration. This legal position is not disputed, so on. So then, based on that, the Honorable Division Bench of this Honorable Court has delivered judgment, proceeding on a premise that the concerned party had due deemed notice of the transaction. My Lord, the other two judgments also, that is Cheruku Maheshwar versus Chatvi Anusuya and Elitome versus Elitome and others, my Lord, both of 2020 and 2021, are to the same effect. In fact, I think they are by the differing bench in the third judgment, but my Lord, the view is same. Lordship would see in Elitome versus Elitome, my Lord, the same point is considered. In paragraph 31 of the judgment. And then even in Cheruku Maheshwar, my Lord, the same is considered. Again at page para 38 of the judgment. My Lord, keeping this in view, my respectful submission would be, there was no question, my Lord, of declaring the suit in any manner whatsoever. And therefore, my Lord, the same was rightly dismissed in toto by the trial. My Lord, the first appellate court, however, makes an exception, and with all due respect, my Lord, I would submit I would show, my Lord, as to how the consideration by the first appellate court is defective in this respect. But the judgment of the first appellate court is at pages, from page 4 onwards. Lord, he makes up his mind insofar as not permitting the suit to proceed. What you could see, he says that the defendant is the plaintiff is not entitled for the 700 square yards of land, as admittedly the property stood sold under registered sale deeds. The Lord may kindly see para 21 of the judgment. Para 21 of the judgment at page 22 of the one. Since the allegations are made by D1 under B2 and B3 on 31/192, which is prior to entering into an agreement of sale with the plaintiff under Exhibit A1. The agreement of sale under Exhibit A1 to the extent of land covered under B2 and B3 sale deeds obtained by the vendors of the husband of D3 and father of defendants 4 to 6 cannot hold good, and such sales under B2 and B3 are binding on the vendor of the appellant plaintiff. Therefore, extents covered under B4 and B5 and the linked documents B2 and B3, that is 700 square yards purchased by the father of defendants 4 to 6, late Prabhakar Rao Bidarkar, cannot be claimed either by plaintiff or her vendor, defendant number 1. Therefore, I am of the considered opinion that the appellant plaintiff is entitled to seek specific performance of agreement of sale A1 only to the extent of suit land, after deducting the extent of the land purchased by late Prabhakar Rao Bidarkar under B4 and B5, that is 1607 square yards. This is how he deducts. Now, pausing here for a minute. Lordship has seen Exhibit A1. Lordship has seen the cryptic manner of averments in the plate. Lordship has seen the manner in which D1 writes his written statement. Lord, it is not as if I could have created B2 and B3 and B4 and B5 subsequent to the filing of. In fact, both the courts felt that they are binding upon the D1 naturally and therefore of the plaintiff. In such a circumstance, the question which I asked to myself is, how can the Exhibit A1 come into existence itself? Well, it is one thing that you permit a part of it if that was in doubt. What I am trying to say, my lord, is, as I said in the beginning, the whole transaction was otherwise than an alleged agreement of sale. So whatever land originally stood in the name of D1, they took an agreement from him and they showed some consideration paid. And thereafter, the whole manner in which the case has progressed, the averments, the manner in which they are made. But if I say that I am the owner of 1607 square yards and I have already shown to have sold 3 years prior thereto, 2 years prior thereto, 700 square yards part of land, where is that due diligence? Where is that inquiry by this purchase agreement of sale holder, by the plaintiff? Where are the bona fides in that respect appearing on the face of record? Lordship would see all these questions which ought to have been considered by the First Appellate Court. The Honorable First Appellate Court was not doing a gratis to us by disallowing the claim of the plaintiff for 700 square yards. Definitely that ought to have been done, which has been done. But then, my lord, does that effect of that 700 square yards admittedly not belonging to the D1 and then to be sold to plaintiff, my lord, has to have on the remaining part of the transaction also. The whole thing was per se unbelievable. Well, my lord, that has not been done. And then what the trial court, what the First Appellate Court does is, my lord, it proceeds. What the First Appellate Court did, your lordship may kindly see thereafter. In the last lines at page 23. In the present suit also, Exhibit A1 is admitted and receipt of total sale consideration by D1 is also admitted. And therefore, burden is on defendants. My lord, total sale consideration was not admitted. Lordship recollects D1's written statement. He said the further amounts were not paid. And he said that in fact, plaintiff said, he sent me a message that he is not interested in the transaction. Therefore, I returned him the amount. That is the plaintiff. Now, this learned First Appellate Court judge, I don't know from where he gets this, that the receipt of total sale consideration by defendant number 1 is also admitted. But such a substitution cannot be made by the Honorable Judge to the facts of the case. And therefore, the burden is on the defendants to establish that the plaintiff has not come forward to obtain sale deed. Defendant number 1, though pleaded that the plaintiff intended to resign from the agreement of sale and received so and so for the cancellation of agreement of sale by passing receipt to such amount, no oral or documentary evidence was brought on record to prove such pleadings. Therefore, defendants failed to prove that the plaintiff was not ready and willing. Well, defendant, how can I prove? I am not a party to the transaction. In fact, I am saying that I am a sufferer. But the manner in which the first appellate court makes these observations, sweeping observations, to justify an erroneous finding is pre-passed. In Allah Bharat Numma so and so, it was held by Lordships in para 16 that undoubtedly the supporting for computation of limitation under 54 Act, Article 54 is the date of refusal by the defendant to perform his part of the contract. Therefore, unless it was specifically pleaded by the appellant defendant hearing that there was a refusal on his part, be it through cancellation or agreement of sale or through a procedure known to law, it would be identify the specific starting point except the date of return of A6 notice. In the present case, the plaintiff and her husband approached the defendant in the first week of April 98 and requested him to execute said in for a plaintiffs in terms of the agreement. But the defendant number one developed non-cooperation and postponed the execution by 1 week, and thereafter stopped responding to the request of plaintiff. The trial court answered the issue of limitation under issue number 1 in favor of plaintiff by holding that the defendants failed to prove exhibit A1 is barred by limitation. Since the respondent defendant do not choose to challenge such findings, the same holds good. The learned first additional senior civil judge erroneously held at page 7 of the judgment that the plaintiff filed her chief affidavit as PW2, but she did not enter into witness box, resulting so and so. Then, my lord, he refers to some of the part of the convenient, not selective part of the evidence. And finally, he proceeds on a premise. Lordship may kindly see the next page, 23, middle of the page. Even the finding of the trial court that the conduct of the plaintiff in keeping quiet till 98 without issuing notice shows that the plaintiff is not ready and willing to perform her part of contract is incorrect. Because plaintiff admittedly paid, I don't understand from where the learned judge gets the deduction admittedly paid. Defendant number 1 has not admitted, and apparently we are not parties to this. Admittedly paid the entire sale consideration amount under Exhibit A1, and the same was admitted by defendant number 1. Therefore, non-issuance of notice in writing by itself cannot be construed that the plaintiff is not ready and willing to perform his part of the contract. Plaintiff pleaded about requesting D1 to execute registered sale deed and also deposed before the court about the same. Defendant number 1 failed to give evidence to deny the claim of plaintiff. Therefore, the oral demands of the plaintiff with D1 remained unproved, and the finding of the trial court on the oral demands of the plaintiff is incorrect. The findings of the trial court in para 25 of the judgment, the plaintiff failed to establish that he is always ready and willing to perform his part of the contract, and further plaintiff failed to prove the receipts filed by him regarding balance sale consideration under A2 to A20 by examining any person relating thereto is also not correct. Because the payments of balance sale consideration pleaded by the plaintiff are categorically admitted by the vendor of the defendant number 1 himself in his written statement, and such payment of entire sale consideration itself shows that the plaintiff is ready and willing to perform her part of obligation. Since the payments claimed by the plaintiff are admitted by defendant number 1, it is well settled law that the admitted facts need not be proved. Lordship may kindly see this entire consideration. I don't know from from where does he gets that admission by D1 of entire sale consideration. D1 only said there was an agreement. An agreement only mentions payment of part sale consideration. Lordship may kindly see further. Therefore, from the above facts and circumstances of the case and evidence available on record, I am of the considered opinion that the appellant plaintiff is entitled to seek specific performance of the agreement of sale, A1 to the extent of 907 square yards on the suit schedule property, and to recover the sale consideration at the rate of 190 per square yards for the remaining 700 square yards from the respondent defendant number 1. Lordship may kindly see this finding by the first appellate court, my lord, is per se perverse. There is one more thing which I would like to point out, my lord. Lordship may kindly see the receipts for a minute. From page 101. 101, my lord, is for 2,18,000. It is for June 1994. My lord, this document does not mention about any earlier payment or earlier agreement of sale. The lordship recollects. Exhibit A1 does not mention about any earlier agreement for sub-sale. Now, if we see the receipts, the lordship may kindly see page 102. The first exhibit A3, A4, A5, A6, A6, A7, A8, A9, A10, A11, and A12. My lord, are prior to agreement of sale existing. Then the lordship may kindly see A12, A13 is said to be 20th April 1994. Then A14 is again, this also is prior to that. A13, A14 are also prior to. Only receipt subsequent to exhibit A1, my lord, the lordship would find is exhibit A16. A16 also is 30th April, my lord.
That is 30th April.
30th April, so it is prior to 1/6. Then A17 is 2/4, A18 is 11/4, A19 is 1994. This is subsequent. The agreement is 1/6/94. This is subsequent.
A19.
A19. 1994 as advance for sale. My lord, if it was a final payment, it would mention so. Same thing, exhibit A20, 10/7/94. Lordship may kindly see as advance for sale consideration. If I am making the payment complete, my lord, these receipts prior to exhibit A1 cannot be added, my lord, to 2,18,000. Lordship kindly appreciates, my lord, what I am trying to say. 2,18,000 is there in the first receipt, that is 101, and it is mentioned in the document. Payments prior to 1/6/94 you cannot add for payment of balance sale consideration. And so far as at least payment of balance sale consideration, it is only 33,330 and 25. There is no proof of payment of 87,330. which is shown as balance amount due, which was to be paid within 90 days. But from where the first appellate court deduces that admittedly the entire amount has been paid, I don't know. Then the lordship may also kindly see B series documents. Rather, I would say, my lord, under B8 to B10, we have been paying the taxes. We are in possession of the property, and insofar as the documents concerning payment of taxes, or rather averment as to payment of taxes, my lord, by the plaintiff has to be understood, my lord, only in one circumstance. The lordship may kindly see. Because on the basis of exhibit A24, your lordship may kindly see under A21 to A23, the reliance was placed by the first appellate court that Jamuna Boy was paying taxes. Now, my lord, we have specifically put questions to PW1. Your lordship recollects that part of cross-examination. I have asked him on what basis. There was no sale deed executed in your favor. On what basis this mutation was done? He said on the basis of A24. Now, A24, my lord, is the irrevocable power of attorney. That does not make him owner of the property. He was only an agent of the owner. And he says on that basis, the name was mutated in. Therefore, your honor, therefore, my lord, A21, A22, A23 cannot be construed to be documents of possession, because A1 agreement does not show delivery of possession. A2 to A20 do not mention about delivery of possession. There is a two registered sale deeds executed admittedly prior to execution of exhibit A1, which specifically mention about delivery of possession, which are already on record. In such a circumstance, there is a question of delivery of possession on that basis to presume that plaintiff is in possession and is paying taxes, and therefore to give them the decree for specific performance on the basis of that mutation, which is admittedly obtained under in persons of exhibit 824. I am saying admittedly, my lord, because PW1 and PW2, I have pointed out that evidence in the cross-examination to the Honorable Court. Therefore, my lord, I respectfully submit. Now, my lord, your lordship may kindly see the page 3, my lord, page 2 and 3. My lord, the present second appeal filed by the plaintiff, 620. My lord, they say the lower appellate court, having rightly reversed the judgment and decree of the trial court, has committed a serious error in not granting the relief of special performance in respect of entire suit land of 1607 square acres. Then, when the substantial question of law, when the appellate court has accepted the claim of plaintiff and decreed the suit in respect of 907 square yards, whether it could have segregated the said 907 square yards from the suit land and measuring 1607 square yards, and whether the denial of the relief of specific purpose for the balance extent land of 700 is sustainable in law. The appellate court reverses the judgment. When the appellate court reverses the judgment and decree of the trial court by which the suit for specific purpose has been dismissed, can the appellate court grant part of the relief of specific performance in respect of 907 square yards and deny the relief in respect of balance 700 square yards? Well, I would say first part of substantial question of law is correct. That in fact there could not have any decree for specific performance at all, even for 907. Then when the appellate court has recorded findings to the effect that the plaintiff has proved suit claim, whether it can restrict the relief of specific performance to 907 square yards only and deny the relief in respect of balance 700 square yards, whether the lower appellate court has exercised discretion.
Leave it to me, I will ask you that.
My dear friend, wait for a minute. Whether the lower appellate court has exercised the discretionary jurisdiction under section 20. Now, my lord, some new law I am learning today. Lordship may kindly see Transfer of Property Act section 54 mentions clearly that property stands transferred by a document a transfer interval. Admittedly, my lord, under B2 and B3, my lord, the property stood transferred. So D1 did not have a right to enter into agreement of sale in respect of the 700 square yards. Where is the question of the agreement having been proved and therefore he being entitled for the decree for specific performance for the entire land? I respectfully submit, my lord, this is it is totally rather I would say they are not entitled to raise even such a plea, especially in the face of, and in fact, if I recollect correctly, I cannot prove that. If I recollect correctly, I understand that we argued the matter before district court. If I recollect correctly, there was a discussion in this respect that if not for 1607 square yards, excluding the area. Anyway, Bharat, I'm submitting that even otherwise, any which way we make exceptions as counsels. But I would respectfully submit that in view of the fact that this casts a serious black cloud, the very fact of admitted alienation. I'm saying admitted because they are by registered documents. Alienation in favor of the vendor of the defendant. Way back in 92 itself. Well, exhibit A1 agreement is itself under a cloud, not just for that area, but in total. And then, my lord, before I conclude, my lord, I would respectfully say that the manner in which, in a sweeping manner, the first appellate court makes these observations. My lord, I have shown methodically by showing the receipts exhibits B20, A20 to A21, A2 to A20. Where is that payment of balance sale consideration? From where the first appellate court gets admitted. Only the two receipts which are remaining, my lord, I have shown as to what is the total thereof. Apparently, this was some other kind of transaction which is sought to be misread by the appellant, my lord, in SA 620 of 2017. So therefore, I would respectfully submit that while dismissing SA 620 of 2017, there are the other two second appeals we kind of grant. Objection.
Right, well.
Was that game.
I'll just give the names of the parties in these three second appeals. One after the other. Second appeal number 457 of 17 is filed by S. Venkatesh. And second appeal number 970.
S. Venkatesh is D2, I think.
S. Venkatesh, B. Narendra, B. Rajendra, B. Ravindra. Or 4 or 5. Defendants 2, 4, 5 and 6 are filed, sir.
Defendants 2,
4, 5 and 6.
4, 5 and 6. Are there perhaps? Then second appeal number 970 by 17 is filed by a third party seeking leave by name, person by name Motilal Jain. My first submission is that as per the first submission is this. An appeal lies against the decree and not against the judgment. Section 96, subsection 1. Read with order 43. And order 41 and order 42. Order 41 applies to first appeals. Order 42 applies to second appeals. And all the provisions of order 41 are applicable to second appeals also. Now you also may kindly look at the first appellate court's decree. The decree is at page number 20. The point which I am driving is this, that these two second appeals are not maintainable in law. That is second appeal number 457 of 17 and second appeal number 970 of 17 are not maintainable in law. And the question of going into the merit of the correctness of the first appellate court judgment does not arise insofar as these two second appeals are concerned. I will give the reason. It is apparent from the decree of the first appellate court, which is at page number 29. Before the decree is seen, my lords may kindly see the amended plaint, which is at page 54. Plaintiff, my lord, Tupakula Jemnabai, at page 54. First defendant is P. Narasimha Reddy, the admitted owner of the suit schedule property 1607 variants. Then defendants 2 to 6 down below in the bracket portion you also will kindly see. Defendants 2 to 6 are added as per the court order dated 3/7/2008. In IA number is kept blank. There is some IA of 2007. So they got impleaded as defendants. And coming to the relief claimed in the suit, prayer at paragraph number 7A, which is at page number 62.
56.
56. Yes. 56. There are double numbering. At 7A, a decree for specific performance of the agreement of sale dated 1/6/94 executed by defendant. This is first defendant. This is the amended plaint. In the original plaint, against the sole defendant actually. the relief is claimed against the sole defendant. And in the next prayer B also, a permanent injunction restraining the defendant. There is a correction merit insofar as prayer C is concerned. Permanent injunction restraining the defendants of alienating the suit plot 1,607 square yards. Now, kindly see the trial court dismissed the suit merit outright. Therefore, it's a plaintiff's first appeal. And the decree of the appellate court is at page number 29. Page 29, decree in AS number 297 of 2010. In this, the array of the parties remains the same, and the operative portion of the decree is at page number 32. That the appeal of the appellant be and here judgment and decree dated 9/4/2010, passed by the learned first additional senior civil judge in OS number 241 of 98 is set aside. 3. This is very important. Further, defendant number 1 is directed to execute and register sale deed in favor of the plaintiff with the expenses of the plaintiff within 3 months from the date of judgment for the extent of 907 square yards in the suit schedule property, excluding 700 square yards acquired by defendants 3 to 6 through registered sale deeds covered by exhibits B3 and B4. Well, that is sufficient for us. So, the appellate decree, which is the decree in the suit, is directed against only D1. There is no decree insofar as D2 to D6 are concerned. When the appellate court has not granted decree, when the trial court has not granted decree, appellate court also not granted decree against D2 to D6, second appeal by D2 to D6 is not permissible in law. There is no provision in the CPC millet to file appeals by leave. Appeals are provided by the statutory provisions of the Civil Procedure Code contained in section 96, the substantial section, and order 41 and 42. Therefore, a person who has not suffered a decree, he may be having a sale deed, that's a different aspect altogether. If he is having a sale deed, then he can claim his title under the sale deed. I laboriously argued saying that I have got sale deeds of 1992 and 1994 which are exhibited as exhibits B2, B3. I am not entering into the factual aspect at this particular stage. So my first submission is that a second appeal by a defendant against whom there is no decree is not maintainable in law. This applies to defendants 2 to 6 as well as the person, Mr. Sri Motilal Jain, who has filed SCA number 970 of 2017. Therefore, on this particular preliminary objection, that these appeals do not warrant adjudication on merits of the case. This is my first submission. Then, the ancillary submission to this is this. The person who suffered the decree, defendant number 1, has not filed second appeal. So the first appellate court judgment has attained finality insofar as D1 is concerned, and a decree against D1 cannot be upset by defendants 2 to 6. The stand is different. They may sue him, they may prosecute him for having entered into an agreement of sale, or they may independently ask for declaration of their title under the sale deeds which are exhibited in this particular suit. Therefore, as long as the one who has suffered the specific performance decree has not challenged it by way of a second appeal, the second appeals filed by D2 and D6, the D2 to D6 do not require any adjudication insofar as the decree which is directed against T1 is concerned. This is the first submission. Second submission is the written second submission. I just formulate my contentions for it. Second submission is this. Written statement filed by defendant number 5. Well, it is not to be treated as a pleading at all because there is no claim against D5. The plaint is not directed against D5. That written statement under Order 8 can be filed only by a person against whom a relief is claimed under Order 7 by the plaintiff. When plaintiff has not claimed any relief against D2, they might have got implemented merit. Implement, perhaps the court generally orders under Order 1 Rule 10. But mere implement matter will not clothe them with a right to contest the suit which is directed exclusively against D1. So defendant. It is easy to say, but these specific performance suits are two types of collusion in my experience. Either it is a collusion between the purchaser and the original owner, or it's a collusion between the original owner and the agreement holder. They are like that, Malad. We have been living in this system. So that will not take us anywhere insofar as the legality is concerned. My humble submission is that the written statement of the 5 which has been adopted by the other impleaded defendants cannot be looked into by the court as a pleading because response to plaint can be given only by a contesting defendant. This is my second submission. And when pleading itself cannot be looked into, any amount of evidence. Now kindly see, Malad, as to the persons who have given oral and documentary evidence before the trial court from the appendix of evidence of the judgment of the trial court at page number 50. At page 50 is the last page of the judgment of the trial court dismissing the suit. Then there are 3 witnesses for the plaintiff. That is not necessary for my submission. For the defendants, DW1 is B. Narendra. Narendra is impleaded defendant number 4. And DW2 is Venkateshwarlu. Venkateshwarlu is not one of amongst D2 to D6. So he is a non-party as far as the cause title of the suit is concerned. Then, at the same breath, Malad, you'll also kindly see the documents that are exhibited for the defendants. These defendants are 2 to 6, not 1. Exhibit B1 is the Xerox copy of the chief affidavit of PW3. That is only PW.
DW2 is Venkatesh, D2.
Venkateshwarlu and Nandani.
Yes, Venkatesh. Last way.
My learned friend says, Malad, that Venkateshwarlu and Venkatesh are one and the same.
He is 94, but
Maybe I assume so.
D2.
D2. D2. It is strict sense according to my argument. But in the array of the cause title of the suit, he is second dependent. Then,
in the chief affidavit, he stated he is second dependent.
That's why I said, anyway, I don't feel he can say what.
well, it kindly see exhibit B2. I don't know. P1 Malad is the Xerox copy of the chief affidavit of PW3. PW3 is there actually from the plaintiff side. So that may be skipped. B2, B3, B4 are the certified copies of the sale deed document 1294, 1295 of 1992, and then B4 and B5 are again certified copies of the sale documents 365, 368 of 1995. Well, my submission, my third submission is this. Certified copy of a document would become admissible only under section 65 of the Evidence Act. And these are all registered sale deeds. They are filed by the persons who claim to be purchasers from Narasimha Reddy. They must have had in their possession the original sale deeds themselves, but none of the original sale deeds corresponding to exhibits B2, B3, B4, B5 are on record, are not exhibited before the trial court. And absence of explanation for non-filing of the original sale deed and for filing of the secondary evidence is absent in this case. So it cannot be automatically inferred that these are sale deeds which are executed by Narasimha Reddy D1 in favor of these implemented defendants D2 to D6, two of them prior to the agreement of sale in the year 1994 and two of them after the agreement of sale in 1995. So these documents, these certified copies of the sale deeds will not fall for consideration before the court for non-filing of the original registered sale deeds. Well, this argument is without prejudice to my first contention about the maintainability of the appeal. Otherwise, it will be contradictory argument. So, blaming, sorry for the expression. So, alleging or contending that Narasimha Reddy has defrauded the purchasers, well, it is something which is perhaps one's imagination, but it is not on record because well, it could have been possible for them to ask the court to issue witness summons to Narasimha Reddy to come to the witness box and depose. Steps could have been taken, Mallet. I don't need, because Narasimha Reddy did not seriously oppose the suit claim. And since they are the real contestants in the suit, they could have filed an application, Mallet, under Order 16 for issuance of summons to D1 to enter the witness box, and they could have cross-examined him with reference to their earlier sale deeds. They have not taken steps in that context as per the record which is before the court. Therefore, it cannot be inferred that Narasimha Reddy has earlier sold a part of this land. The trial court, Mallet, has given some sort of concession on the basis of this certified copies, excluded 700 square yards and granted decree in respect of 900 square yards. It worked more like a suit for partition, Mallet, in the final degree proceeding. The big performance suit could not have been done like that at all. So these documents may not be taken into consideration by the Honorable Court for want of exhibiting of the original sale deeds and compliance of the requirements of section 65, that the original is lost or kept in with a financial institution as a mortgage or any other, or it is misplaced, whatever it is. There can be 100 explanations on that. That's 65 and 66 of the evidence. So if these sale deeds are excluded, then it becomes a simple suit for specific performance, which can be challenged in an appellate court only by the parties to the agreement. And next submission, Malad, insofar as their appeals are concerned, next submission, fourth submission of mine is this, that this DW1 and DW2 are incompetent to depose anything about the suit agreement of sale exhibit A1, because they are neither parties to that nor they know about it. I wonder, Malad, in fact, as to why they got impeded in this particular suit, because they have registered sale deeds in their favor. Along with the registered sale deed, Malad, there will be a delivery of possession clause, and they must be in possession of that particular 300 and 400 square yards, totaling to 700 square yards of land. And if anybody is interfering with that particular portion of the land, their remedy, Malad, is to file either suit for injunction or suit for declaration of title and injunction, which I think is open even today also, in spite of the judgment. Because a person can convey a title provided he has got the title. Now the court directed D1 to execute a sale deed in favor of the plaintiff. Even if this takes place, then the sale deed will be a second sale deed of the same property. Section 47 of the Registration Act says, Malad, the first of the sale deed will prevail over the subsequent sale deeds. So the title of these persons, that is D2 to D6, claiming under exhibits B1, B2, B4, B2, B3, B4 and B5 is no way affected by the appellate decree. Therefore, they do not have locus standi to, they do not have any grievance. Locus standi, Malad, is not in civil law. They do not have, they cannot project any grievance about this particular decree at all, because they are already having registered sale deeds in their favor if they belong to the same parcel of land. The boundaries vary, Malad, then that's a different case altogether. But we have been arguing that it is the same land, therefore portion, Learned Appellate Judge Malad has divided it into two pieces like cutting of a cake. So in this appeal, that is these two second appeals, my humble submission, Malad, last submission is this, that none of these D2 to D6 can contend either about the exercise of discretion under section 20 or that the suit is barred by limitation. Barred by limitation in the sense that not filed within 3 years' time, or non-payment of consideration or part of the consideration, because consideration will never go to them. Consideration is paid, it will go to Narasimha Reddy only. And if any person would come forward and says Narasimha Reddy, well, a written statement averments. I may here amplify my argument saying, written statement is not equivalent to an affidavit. Written statement or plaint is also not equivalent to an affidavit filed under Order 19. Written statement, Malad, is a pleading. Evidence is oral and documentary evidence. Therefore, the the argument built on the written statement of D1, who never entered the witness box. Right? A person can file a written statement, but if he abstains, then the settled law is that if a person does not enter the witness box, we have been citing that case from AIR 1999, Justice Sagira's judgment, that an adverse inference has to be drawn against the person who has disallowed cross-examination by the other side. Therefore, the contentions of defendants 2 to 6 on the merit of the claim for specific performance merit do not fall for consideration. The last is this. Substantial questions of law are not clearly formulated, except saying that the judgment of the appellate court is perverse. Look, perversity is from the point of view of the aggrieved party. He would say that it is perverse. So there are no substantial questions of law in these two appeals warranting any interference. Again, I say, my lord, that these contentions of mine are without prejudice to the first contention of mine. Then my learned friend has cited case law. I would just give the settled propositions, my lord. But under your lordships have seen Exhibit A1 agreement of sale. I will not read it again. Time is not the essence of the contract. Payment of the balance consideration amount within 3 months would not make time as the essence of the contract. Kamal Rani versus Chandrani, that judgment, 1993, 4 judges of the Supreme Court. I will just pass on. Your lordships are well versed with that particular law. And the citation that will be 1990. Just give the citation.
Yeah, Delhi High Court.
Supreme Court. That is 1993, Volume 1, SSC, page 519. 1993, Volume 1, Supreme Court cases 519. Settled principle merit. Even if time is the essence of the contract, subsequent conduct of the parties merit will have to be looked into. That was the law that is laid down there. Therefore, on the strength of that, for 2 reasons. One is that the Exhibit A1 agreement of sale does not make time as the essence of the contract. And secondly, there has been no exchange of notices between the parties about the payment of the balance consideration amount. And most importantly, Marat, refusal by Narasimha Reddy to execute sale deed. What is pleaded in the plaint is that he has been postponing. And in the written statement, there is no categorical statement. And there is no evidence also that he has refused to perform this agreement of sale on such and such a day, and 3 years from the date of the refusal under Article 54 of the Limitation Act. Therefore, there is no bar of limitation. And then another landmark judgment of the Supreme Court is that when time is not the essence of the contract, it has to be suit has to be filed within reasonable time. That is the law item in 2003, volume 10. Supreme Court cases. 2003, volume 10 SCC, page 390, paragraph number 31 and 33. Well, this is in fact a very good case than what was before Supreme Court. So after 6 years the suit was filed, they said it is not within reasonable time. Here, Malad, it is filed in 4 years. Therefore, there is a distinction. They have also referred to the famous judgment Vaidyanathan's case also, Malad, this. Then, the last of the decision which I want to cite is this. Now, Narasimha Reddy, Malad, owner, admitted owner. Narasimha Reddy, if he has really executed the sale deeds in favor of these implemented defendants, the originals of them, then he is the best person to have knowledge about that, not the plaintiff in the suit. Because Narasimha Reddy offers to sell, and the consideration is fixed. Well, there is a principle which is laid down in the judgment reported in 2015, one SCC. (2015), volume 1 SCC, page 705, paragraph number 33. Three lines in paragraph number 33, Malad, are very, very crucial in specific performance suits. Let's kindly see only paragraph 33, Malad. I will not travel with other paragraphs.
Sir.
Paragraph 33. The equitable discretion to grant or not to grant a relief of specific performance also depends upon the conduct of the parties. The necessary ingredient has to be proved and established by the plaintiff so that the discretion would be exercised judiciously in favor of the plaintiff. This sentence I am relying on. At the same time, that's how it starts. If the defendant does not come with clean hands and suppresses material facts and evidence and misleads the court, then such discretion should not be exercised by refusing to grant specific performance. This line of decisions, Malad, are found in clarity. This is the judgment, Malad, of 2015 Supreme Court. This is Iqbal. So, if the defendant does not place the suppression of fact, then he would suffer a decree for specific performance. Here, first defendant, Narasimha Reddy. Sale deeds made by him, he has not disclosed. If your lordship kindly have a look at the written statement filed by him, he mentioned the name of one Vinayak Rao. Vinayak Rao is not defendant numbers 2 to 6 at all. What he pleads is that a relative of the plaintiff, Narasimha, said that he will nullify the agreement of sale transaction. And on that particular understanding, he sold it to Vinayak Rao. That's what he pleads. Because he did not enter the witness box, nobody could elicit any further information from that first defendant. So, my humble submission is that the specific performance decree should be suffered by Narasimha Reddy on this principle that he has not placed the truth before the court. What consequence it will have, Malad, is altogether different. Whether Yamuna Rani will get title or the earlier purchasers would continue to have title, Malad, is a matter which is outside the scope of this particular specific performance suit or the second appeals which the Honorable Court is now hearing. So these are my submissions, my lord, in these two appeals. I have to argue the other appeal. My lord, may I just make this suggestion, my lord, to your lordships. Your lordships may deal with these two appeals first, and then hear the other appeal, my lord, later. If these appeals are allowed, it may not be, perhaps it will be cumbersome to hear all of them at a time. Assuming that these second appeals are allowed, then the suit stands dismissed.
When all the appeals are against the same judgment, okay, will it be okay if I hear two?
No, they want a larger relief, I want a smaller relief. I have got a relief insofar as 900 square yards is concerned, and I am denied relief insofar as the 700 square yards is concerned. That is the area of controversy in my second appeal. Or I will make submission in that also, so that you will
a common judgment we can dispose it.
Then coming to that, the substantial question of law which I raised is this. There is no plea that when the court has come to the conclusion, appellate court came to the conclusion that Narasimha Reddy did not dispute the agreement of sale. And another, I have to answer about the signature of, well, again, this is part of the defense which is available only to Narasimha Reddy, not to these repeated defendants at all. And it is settled law that in an agreement of sale, signature of the vendor is of vital importance, not the vendee. There are judgments on that. I have argued myself before Justice Rao. And it is laid down that the vendee is before the court asking for specific performance, whether the signature is there or not. There is a difference between execution of a document and signature on the document. Execution is the bargain between a transaction between the parties. Signature, my lord, is only a vouchsafing of the transaction between the parties. Signature by itself, my lord, does not give anything because the other terms and conditions are there. And when the plaintiff comes forward to enforce that particular document, it is inferred that the plaintiff wants the enforcement of the document, therefore whether that signature is there or not. If it is denied by the defendant, that's a different matter. Then different consequences would flow. So the absence of signature on Jamuna Rani or the plaintiff on exhibit A1 mallet is not of any consequence insofar as the adjudication of the suit is concerned. Then the substantial question of law raised in the second appeal 620. My learned friend has read out to your lordship, I will only just pass it. 620. Appellate court grants me a decree for specific performance saying that which event exclusion of 700 square yards on the ground that they are covered by the earlier sale deeds. There is no counterclaim here. But had there been a counterclaim by defendants 2 to 6 that declare them as owners of 700 square yards from out of 1607 square yards, then their counterclaim perhaps would have been decreed. In which event, then the suit schedule property will become only 900 square yards. So, in the absence of a counterclaim by D2 to D6 and in the absence of the
bill. Yes, sir.
Evidence of the first defendant that he has sold 700 square yards, and also for the same argument, Mallet, that the originals of these sale deeds are not placed before the court and only certified copies are at the court. The appellate court, while decreeing the suit, could not have divided the relief as though it is doing a conciliation between the plaintiff and the defendant. You take 900, they will take 700, which is legally not permissible. Therefore, relief could have been granted in toto or it could have been denied in toto. The suit could have been dismissed. Otherwise, the suit should have been decreed. Consequences are not relevant. Well, no judgment of the court would ever be given by a court of law. Thinking about the consequences. Small example, 1 minute time I take. In Shabarimala, prohibition of female entry into the temple case. The Supreme Court, they never thought of the consequences when it gave the original judgment. Now it is under review, that's a different matter altogether. So, consequences of a judgment are not in the mind of the court when it is dealing with the rights and liabilities of the parties while adjudicating a particular list, whether it is civil or whether it is other jurisdictions of the court. The consequence in a death case, in a murder case, if suppose somebody is hanged, then their family, how will they survive? Therefore, the death sentence should not be imposed, will never enter into the mind of the court, except that the offence is heinous and that the prosecution has proved the offence. Therefore, whether the family of the accused who will be hanged by the court, by the judgment, they will be on the streets, would never be taken into consideration by the court in giving a judgment. Similarly, my lord, in civil law or any other law also, the consequence is not relevant. Therefore, the appellate court, without any basis and in the absence of the original sale deeds and confrontation of those original sale deeds to Narasimha Reddy, could not have stripped off the 700 square yards from the entitlement of the plaintiff from specific performance of the suit agreement of sale. This is my submission, Merit, insofar as my appeal is concerned. That's
Reply, your lordship may kindly have quoted. But has given some judgments. Therefore, requesting proposition is put forth.
More particularly, I want to hear from you also about that particular objection about the maintainability of the appeal by the parties. D2 to D6.
I'll submit.
We'll have it on 15, sir.
15.
All right. I'm fortunate to hear two senior counsels, and that too in an interesting matter. I enjoyed the argument.
It will not be interesting matter like life. We have to make it interesting.
Yes, both of you made it.
I think your lordship follows little Hindi also.
Yeah, I can understand, but I cannot speak.
Friend asked me, Malad, wakalat kaisa chal raha? My answer is, wakalat kabhi nahi chalta, chalaya jata hai.
Thank you, sir.
రెడ్డి గారు వెళ్ళిపోయారు 2 weeks ఇవ్వమని చెప్పి
డేట్ ఇచ్చేసి రిక్వెస్ట్ అనేసి ఇంకా
జడ్జిమెంట్ ఐటమ్
79 there
ఐటమ్ 79
none appear
ది చంద్రసేన్
none appear 1711 same caption 80 date ఇచ్చాము
ఐటమ్ 81 82 ఐటమ్ 81 82
8182 dismissed 83 also dismissed కాపీ అక్కడ టైప్ చేసినట్లుంది